Was that? The only day. Well, they were in the action yesterday. I guess they went up to a couple of them went up to Arkansas. And I asked them, the kids they well, it's more, always yeah. Pretty new at school, and this is fairly uncomfortable. I wasn't there, but,
presiding.
Please be seated. Well, good morning. We are very, very pleased to be here today to show you a little bit about how the Supreme Court actually operates. But before we begin with that, I think Judge John Anderson has some remarks he would like to make. Judge Anderson?
Thank you, Chief. May it please the court, justices, and members of the public and fine guests, welcome to Bayfield County. Welcome to our historical 1896 courtroom. Obviously, the Supreme Court does not reside in Bayfield County every day. I think we would have noticed it by now. I want to welcome the Supreme Court to our wonderful shores, to the outer rim of Wisconsin, the far north, and I hope you enjoy your stay. And we appreciate the opportunity that you've given us to let the citizens of the north watch how the court works and watch how the work of the people is done on a regular basis. And I think it's very important that the people understand how our court system works, because so much of it is done without fanfare, without press, but there is a lot of work that's done by the court every single day. A welcome, before I do any more formal welcome, I would like to thank a few people at the county. First of all the staff members from Bayfield County that we have inconvenienced over the last few days. I want to thank very, very much. Our IT staff has worked with Wisconsin Eye and the audio, and they did a fantastic job. Our maintenance staff bent over backwards to make sure that the accommodations would be available for this, and I really want to thank them. I also want to thank our county administrator, Mark Allison, with his support and support of the county board. We were able to bring the Supreme Court here. I also want to thank Sheriff Paul Stinka. Paul has made sure that this is not only a safe environment for everyone today, but an enjoyable environment. And in the present day, when courts and law enforcement work in collaborative efforts to reach effective justice strategies, the justice system and the sheriff's office in Bayfield County work together hand in hand to put together programs that are very effective. Sheriff Sasenka is a forward-looking, very smart man. It's an honor to work with him. Of course, any welcome to Bayfield County would be short-handed if we did not recognize everyone. And even though my ties here go back 6 generations, I'm a little old. And my parents are here, actually, representing the 3rd generation.
Have them stand up.
Mom and Dad, stand up. However, the original people, the Anishinaabe, were here long before my ancestors came. And they need to welcome the Supreme Court here as well. We have a tribal elder from Red Cliff, Marvin DePole, is here to present a welcome in the traditional Anishinaabe language.
Bonjour, everyone. I just want to start off with bonjour. That's how we say hello in our language, and please understand I'm not speaking French. I'm saying bonjour. It comes from an entity of our Wayne bonjour. It's a high honor when I use that. So I'd like to bonjour to the Chief Justices here. Welcome here amongst us. And I also like to acknowledge our tribal judges, Steve Bully and Gwen sitting right next to me. I also like to acknowledge the county judges here, Mr. Anderson, and also the attorneys. Also the attorneys that are here, the county attorneys, our tribal attorneys. I'd like to acknowledge them also. And I also like to acknowledge the workers. I just met the marshal this morning, and I see how important it is to have the workers amongst us to kind of keep things in order, to keep things going. So I'd like to acknowledge the workers. And finally, I'd like to acknowledge the community of Bayfield County that are also here amongst us. And I also acknowledge our tribal people here amongst us. I'm going to talk a little bit in English, and I'm going to talk in my language that was given to us and been spoken on this land for hundreds and thousands of years. But I want to start off with my father. My father taught me something, and I grew up with that. And he said, when you shake somebody's hand, you make an agreement, you always honor that. You always honor that when you shake your hand, somebody's hand. So when I shake somebody's hand, that's like an agreement to me, how I grew up. And also amongst us, certainly we have certain rules and certain laws and certain protocols. Even our own families have certain rules and protocols, laws and rules of the parents or the rules in the household. And certainly when they get broken, some of us as parents, we do certain things, we discipline and we correct our children in our house. The laws, the way I see the laws amongst us, certainly are made to, as well as we do that to our children, because we want to cause no harm and we want our children to raise up and be good children and be good people, as well as the laws of the land to help guide our society, and to help guide us as human beings so that we have a ways to follow. And sometimes those laws need to be interpreted. Sometimes you need to have a meeting, as well as I know myself as a parent, sit down with my wife and interpret some of the laws. And certainly as well as the justice here today is going to interpret some laws for us today. The reason why I talk like this too is because there's a law, and there's some laws that are unwritten. There's laws that are natural laws. And that's what I'm going to talk to this morning, to acknowledge, as well as I acknowledge those of us here, to also acknowledge the natural laws amongst us, the earth that we walk upon. It's like this. It goes like this. It goes like in the springtime. There ain't no leaves on the tree. Of course, the leaves are leaving now, but in the springtime, you see leaves on the tree. And it always amazes me to kind of see that Bamadazi wind, what I call it in my language. Some people call it photosynthesis. Some people may call it energy. Some people may call it different names and different things for that. But we're all talking about the same thing. We're all talking about the same thing. We're all talking about the same earth that we walk on. We just may call it a little different ways. But it's the same thing. So I'm going to take a few moments to acknowledge that sun that came up this morning. I don't know if some of you were up that early to see it, but I kind of seen it peek out for a second this morning. And to acknowledge the sky, the moon, to acknowledge the stars that shining up above, to acknowledge that lake, which we call Lake Superior, Chigamig in our language, to acknowledge the earth, the grass, the things that walk on the earth, the animals, the trees now that are going to sleep right now so that they can wake up in the spring and photosynthesize, I guess. Now I acknowledge those things in our language. Buju gakena oma. Shigwe banes minoa kwedini gane gabo disnakas. Kite na me do dem. O pegisho wabanun, yawanun, gabian, kwedinun, bema dapana bangesema. O minoa kikam, minoa chigamig, manido bema dapana no sema. Ishpimingat, gisis manido de makan gisis. Pegisho ishpimingat, no. Manido bema dapana no sema. O pegisho dukwa lakena nagasit dukwa help them today. You know what we dukwa lakena ma pegisho minoa lakena bamada sego life pegisho lakena manido. Minoa wudukwa nishnabe dakena nishnabe oma pegisho dagi gidwin mazinegan oma pegisho wudukwa o abanushi minoa ikwe wog minoa nini wog minoa akawenzi wog minoa mendemuye pegisho nisamanek dagi gidwin. Be rich. Thank you.
Thank you.
Thank you, Marvin. I would like to point out that in Bayfield County, we fly the tribal flag as well here and in the courtroom downstairs. Justices, welcome to our shores. Welcome to Bayfield County. May it please the court, have a great day.
Thank you. Well, welcome to everybody. I'm going to stand because otherwise I can't see you all in the back of the room and you can't see me, and it's a little easier to talk to one another if we can see one another. As I said, and as our marshal said when we walked in, I'm Pat Rogansack, and I'm the Chief Justice of the Supreme Court. We are very, very pleased to be here in Bayfield County today. You know, we come here at what we think is the perfect time after the Apple Fest, when all of the tourists have come and gone a little bit, and hopefully before a snowstorm, so we're before Halloween. Luckily, we're usually safe if we do it that way. Although this room is now, I guess, used by the county board, it is the original courtroom for Bayfield County, and it retains that wonderful historic feel that a courtroom often has. Judge Anderson told me, and I think he mentioned it last night for those of you that were at the ceremony, that this chair that they gave me to sit in has been used by every single judge of Bayfield County. And in fact, it's original with the courthouse, which was completed in 1896. So he said, if you lean back, don't lean back too far. I'm not a lean backer, so that probably is okay to me, but that's very interesting that this chair has survived us all the things that have gone on in this courtroom. And before I go any further, I want to thank you very, very much, Marvin Defoe, for the wonderful tribal welcome. I don't think I've heard a tribal member speak so long and with a prior explanation before. That was very nice because it made it much more meaningful for all of us what you were telling us in tribal language because you interpreted for us before. So thank you very much. That was very nice and very helpful. Now, it's nice to be welcomed to Bayfield County by so many people and so frequently. Last night, we had a wonderful reception that we all attended that Judge Anderson and his staff put together. But before I go any further, I'd like to introduce you to all my colleagues who are sitting here. And if you wouldn't mind kind of standing up and waving so those in the back can see who we all are. On my far right, Justice Rebecca Bradley. Next to her, Justice Annette Ziegler. Next to me, Justice Shirley Abrahamson. On my left, Justice Ann Walsh Bradley. And next to her, Justice Michael Gableman. And on my far left is Judge Daniel Kelly. Thank you. Now, I want to recognize Judge Anderson. He has been absolutely marvelous in preparing all that's going to happen today and what happened last night, along with his judicial assistant, Nora Tribisi. Is she here today? We appreciate all that you've done so much. I know that I've talked to Judge Anderson often, but not to you until last night. Thank you so much. I know how much work it goes into presenting and putting together an event like this. And it's almost like doing a wedding, you know. Get all these things organized. Now, I want to tell you something about Judge Anderson. Although you've been around him a while, you may already know it. He is persistent, absolutely persistent. He's been asking the court to come to Bayfield County over and over a number of times. And last year, we went to Grant County, and the day I got back, I got a call from Judge Anderson saying, how about Bayfield County? I said, you know what? I'll see if I can put it together, and if I can, we would really love to come. So we worked on it, we did it, and we are very pleased to be here. And thank you for being so persistent. It's really beautiful up here in this part of Wisconsin. Now, we have other judges that are present. I'm going to ask those who I name to stand, but there may be some that I don't have on my list. From the Wisconsin court system, Judge Gary Sherman from District 4 Court of Appeals. And from the St. Croix County, our Chief Judge, Judge Scott Needham. Thank you. And from the tribal courts, Chief Judge Stephen Brule and Gwendolyn Topping. Thank you very much for being with us. Are there any judges present that I missed? And if you are, please stand and let us know. Okay, thank you. We have, I believe, our two legislators are present. Senator Janet Bewley, is she here this morning? Oh, she's sleeping in. We'll get her later. Representative Beth Myers, is she here? She was here last night, too. Good to see you again. Thank you for coming. We are very grateful to the people of Bayfield County. The board chairman, Dennis Pasternich, is Dennis around? Very good. Nice to see you last night, too, and thank you so much. I have a couple of other board members on my list who I think are present. James Crandall, is he here? Okay. And Larry Thickbaum, is he here? Another guy sleeping in, we'll get him. And Jeff Silbert, is he around? There he is, okay. Thank you so much for joining us, and thank you for all the support you've given us as we arrive in Bayfield County. Now, I know our Bayfield County Sheriff is around because I saw him last night and I saw him again today. Would you please stand? Paul, are you here? Thank you so much. And your Chief Deputy, Dan Clark, is he around? Very good. Thank you so much for what you do. It always makes our visits to counties so smooth when the sheriff and the deputy are in charge, and we really appreciate all that you do to help us with that. Clerk of Court, Kay Cedarberg, I saw her last night. Is she here this morning? She may be at her day job. She has helped us a great deal as well. How about William Busey, the Bayfield Corporation Council? Is he around?
He's on vacation.
He's on, okay. And Washburn's mayor, Scott Griffith, is he here this morning? Okay, well, they may join us later on in the day. John, you'll have to let us know if they show up later because I'm not sure if I would recognize them, but I would like to thank them for attending. The Ashland Bayfield County Bar Association president, Katie Posowitz, was there last night. Is she here this morning? Yes. Well, thank you very, very much. And in addition to helping to organize last night and helping to organize what's going to go on at the luncheon today, she also secured 3 attorneys to come and talk with the people that attend our oral arguments to explain the cases in advance. So they get the briefs, they read the briefs, they then put it into a more easily understood format, and before every case, one of the attorneys will come out and speak. Now, I have Jack Carlson. Is Jack here this morning? Very good. Thank you so much. What you do, we couldn't do without, because Justice on Wheels would not be the same. Linda Coleman, is she here? Very good. Thank you very much, Linda. And Tish, Kiana Cruzan, is she here? Hi, Tish. Good. I saw you last night, too. Thank you all so much, and I'm sure that all of those who attend the argument will thank you as well, because you will make what we do much more meaningful and much more understandable. Now, our visit to Washburn County is the 27th time we've done Justice on Wheels, and we've never gone back to the same county twice. So Judge Anderson was kidding everybody last night, probably in our lifetime, this is the last time you'll be here. I don't know, we could be coaxed to come back again. It's so lovely up here in Bayfield County, certainly very beautiful. The goal of Justice on Wheels is to bring the Wisconsin Supreme Court to the public that we serve, the people of Bayfield County today. Public outreach is very, very important to the Supreme Court because the justices are charged with doing the work of the people. So, of course, we want to visit with the people and let them have an opportunity to see a little bit close hand what we do. We usually do the work in Madison, but today, and as we have on 26 prior occasions, we go to one of the counties outlying Dane County and carry on our usual work, but in another county. We hear oral arguments, and we're also going to meet with some students, and Justice Ziegler will help us with part of that a little bit later in the program. Now, although many of you will never, ever be a party to a lawsuit, the effects of this court's decision go far beyond those people that bring the controversy to us that we're going to be deciding on today. That's because the Supreme Court hears cases only if they are of statewide concern. Well, what does statewide concern mean? It sounds like lawyer talk, doesn't it? It means that the results of the lawsuit will affect you even though you're not a party. So that's not the usual case. So what we decide in the cases we'll hear today will have some effect on all of the people in Wisconsin. We as justices take very, very seriously to uphold the United States Constitution and the Wisconsin Constitution because they are the very foundation of our impartial judicial system. We realize that every single person has a stake in our decisions, and we want to be sure that as many citizens as possible are familiar with what we do so they will have the utmost confidence in the Wisconsin courts. We think of one way of doing that is for us to get in our cars and drive on out and see people throughout the state of Wisconsin. Now, I have to say we are particularly pleased to be here in Bayfield County because it's clear that you care very much for the courts. I mean, this building is so beautiful. It's on the National Register of Historic Places, so it's not just I who think it's beautiful, or those of you that have enjoyed it for so many years. It's really quite a bit of significance. You know, before I came up, I tried to get a hold of, what is some of the lore of Bayfield County? Every county has its stories, and stories I always think are fun. And I was told that the county seat was not in Washburn. It was in Bayfield earlier, and there was a lot of planning and a little bit of luck that caused it to be situated in Washburn County. Now, I can't tell you whether the stories I've been told are absolutely true, but they do make fun to retell. And the story goes that there was a far-reaching, very carefully made plot in 1892 to move the county seat out of Bayfield and into Washburn. As part of the plan, the owner of the land on which this courthouse now stands agreed that he would give the land to Bayfield County if they would build the county courthouse on this piece of property. Well, in addition, there was a rumor that was circulated that the old courthouse in Bayfield, why, it would take $10,000 to renovate it. It was in bad repair. And because it did not sit on county land, the county would pay the bill, but the owner of the land would get some benefit from that renovation. So that was the rumor. Well, the question then was put to a county referendum in 1892, and the voters decided that they would change the county seat from Bayfield to Washburn. Well, there were some voters who were very disgruntled, as tends to happen in elections, I'm sure. They were very disgruntled about the change out of Bayfield, and so they said, those records are staying right here in Bayfield. We're not letting them out of here. Well, one night, a group of Washburn men, apparently no Washburn ladies were involved in this caper, they got in their horse-drawn sleighs. They came to Bayfield County, into the old courthouse, and they stole all the county records. And just because they had a little extra room in their sleigh, they also stole the county clock. Now, it's also been said that the records and the clock and the county clerk were all hidden in the brewery for a while in Washburn. Now, I don't know what benefit the brewery might have had to the records, but it might have had a little benefit to the clerk. Anyway, that is how the story goes. It's kind of a fun story. In regard to this beautiful courthouse, in 1894, there was a bid to build it. The building we're in now for $28,670. And it was to begin 10 days after the contract was signed. Well, they hardly got a deep breath on the contract when the contractor asked for an increase of $3,067. Now, if you're looking at $28,000 plus a bit for the whole courthouse, to ask for another $3,000, that was a pretty big jump, but it was given. And then there were some delays in building the courthouse because there were a number of changes to the courthouse plans. But eventually, the courthouse was finished in 1896 for a grand total of $40,022.50. Now, that included not only the building, but drapes on all the windows. Looks like they're gone. We have more modern shades today. Everybody had a phone, and it included appropriate plumbing. I'm not sure exactly what that was. The completed courthouse, however, was quite a marvel. Each office's phone had a different number of rings, so you'd know if it was yours to pick up or if it was meant for someone else. Now, not quite so much as my cell phone, which I have one for my son and I have one for each of my daughters, and they're all not quite a marvel like that, but really for the day, that was quite nice. Everybody had an individual ring. Today, we are very privileged to have not only this beautiful building, but one that also has state-of-the-art technology to meet modern performance standards. And we thank the county board members for their support. They have supported the courts well, just as the county boards supported the courts of Wisconsin in the past, and we very, very much appreciate that. Now, we have a number of traditions that have developed as we've done Justice on Wheels and wandered around the state, and one of the traditions that has developed is that we have an essay writing contest that's conducted in our local schools. Today, Justice Annette Ziegler is going to explain that to you and present awards to the winners in that contest. Justice Ziegler?
Thank you, Chief. It's really nice to be here today. Last night was fabulous, and one of the best parts of being a justice is having an opportunity to come and meet with people like you and speak to groups outside of the court system. So thank you for this opportunity, because without you welcoming us here, we couldn't be here. And don't feel bad, by the way. Washington County is not very far from Madison, and that's where I was a judge for 10 years, and the court didn't come there until I think 2007. So it's not that bad to be a few years later and have us come up here. So Justice on Wheels started in 1993, and a few years later, an essay contest was started. And the front row is full of our winners. Part of the essay contest is that fifth graders, I think 10 and 11 years old. How old are you guys? 10? Right. 10. They're 10 years old. Have the opportunity to write on a topic. And the marshal, or trustee marshal, Tina Nodoff, sends out to all the schools and homeschoolers an opportunity to participate in the essay contest. And having been a trial court judge for 10 years, thousands of cases, I mean, you see all sorts of things, right? And now on the Supreme Court for almost 10 years, you see almost everything, right? Well, I'm telling you, I am always amazed at the things kids can come up with, both at home, by the way, with, the different interpretations of the laws. Kids are very creative in that regard, aren't they? But also in this essay contest. It's amazing what kids think of and how they put pen to paper and how they come up with some really good ideas. The toughest part of this whole thing with Justice on Wheels, in my humble opinion, is the essay contest, because truly everyone's a winner. And I don't say that lightly. These kids are smart and they do a great job. But the court does have to decide a winner. And the court this year has a first and second place because they're both so really good. The two questions that the marshal gave the kids to potentially write on, and they got to select, is describe the rights that you as a child have under the U.S. Constitution or the Wisconsin Constitution, and what are some of the things that right allows you to do. Or they could choose to amend the Constitution and say, what right would you give to children and why? Pretty weighty stuff. And they did a really good job. So for these 10-year-olds, fifth graders in your community, I don't know, is the teacher here? Okay, is it Jim Marsh?
Yes.
All right, stand up for a second. Great job with these kids, by the way. Both happen to be separate classrooms. But Mr. Marsh's students. And thank you for giving us this opportunity to see the good work of your kids. So at this point, what we're going to do is I'm going to give an award to the second place recipient, and also a Wisconsin Constitution and a United States Constitution and a plaque. And then I will award the first place student, and that student will read their essay to us. All right? So you get a little peek into the world of a justice, and one of the most fun parts of it. So Trista Richardson is our second place winner. Trista, can you come forward? Here you go, honey. It's a plaque from the Supreme Court, signed by all of us, which is kind of cool, right? All right. And then the Constitution of the United States, Wisconsin Constitution, and keep up the good work. You're awesome. All right, first place winner, drum roll, Caleb Schoonmaker? Schoonmaker. Caleb Schoonmaker, please come forward. See, you're a star already, you guys. Okay, do you want me to hold on to this while you read? And then I'll hand it to you? It's really cool. Here you go.
My name is Caleb Schoonmaker, and I've come with a request for the Wisconsin Supreme Court. My request is to have children able to vote. We are sons and daughters of our parents, citizens of the United States of America. United we stand, divided we fall. We are divided. Children and adults are divided. We have feelings. There's no old enough or young enough. Everybody is always saying, you can do it, or you're not too young. There are stories of young people changing the world. Let's put these words to use. Voting is vital to the United States of America. Voting for Hillary Clinton or Donald Trump will make big changes in the United States. Those changes affect everyone, including children. Not being able to vote in this scenario allows us to sit helpless. Our life changes so we sit helpless? No child will like the sound of that. Or we could help contribute to those changes and put our thought into them. But the only way to do so is having the right to vote. But we don't have that right. So we only have the first option. But if we gain the right, we have the second option. If a president we vote for loses, we should still be able to try. Council members, could you imagine kids being able to vote, not adults? If there's any women on the council, remember when women weren't allowed to vote? Maybe you have ancestors that were not allowed to vote. You know that 5th, 4th, and maybe even 3rd graders know what's going on. Almost everyone does. You may be thinking, they're just children, but they are too young. Maybe some are too young, so it could be a parent's choice. But the parent could be foolish, you might say. Then why can they vote? Let that sink in. I've made my point of why children should vote. Thus, my essay ends.
Wisconsin Constitution. Both kids were amazing. So that's the tough part of this. That will be our toughest decision today.
Well, thank you very much, Justice Ziegler, and thank you to you students. It's always inspiring to see what young people think about when they think about the court system. We're going to take a little break now, but before we go, I'm going to leave you with words from one of my favorite philosophers, Dr. Seuss. You all probably know Dr. Seuss. He said, "You'll miss the very best thing if you keep your eyes shut. Some questions are complicated, but the answers are not." So don't keep your eyes shut today. We'll be back to see you in a little bit, and our legal aces will come out and talk a little bit to you about the first case that we're going to hear argument on today. We hope you all enjoy your day with the Wisconsin Supreme Court. Thank you so much.
There's someone else who should introduce. I would like to introduce Don Harper, who is District Court Administrator for this district, and he's relatively new, but he loves it already.
Very
so
good.
Thanks, Don.
Thank you so much, Justice Abrams. We'll see you in just a little bit. sure. I got to look all judgy.
Very good. Well done. Good job. I think we're going to pull it off. We're getting dangerously close, except for the actual labor of the court at this point. Everybody else
All
is
I know
set.
is that my part's on. So. Come on down.
Ladies, gentlemen, there's some seats up here. No one will be standing when we start. So if you are not in a chair, come up here and I'll find you one. Thank you, everybody, for cooperating and squishing in and getting to know your neighbors. I'm Tina, I'm the marshal for the court. One of the things I'm going to be doing is sitting at this table, making sure you're all following the rules. And the rules of the Supreme Court audience are no talking. The acoustics are actually better here than when you're at home, but when you're talking, the court can't do their business. So they need your cooperation. I know even the talkiest person can go 60 minutes. No eating or drinking in this room. Only the attorneys, and this is the only time the justices ever get to have water on the bench, so they're pretty excited about that. But we're going to respect this room. Nobody's going to eat and drink other than the folks who are doing business. Make sure your phones are off or silenced. No electronics are being used in this room during the oral argument. I'll be watching. If I see you on your device, I will take it and text the most rude things to your contacts. Good luck, everybody. And we are going to have an attorney from Bayfield County somewhere. Is there an attorney who's going to... She is going to tell you about the case. She'll introduce herself and give you a little warm-up about the case so you know what you'll be hearing.
Thank you. Good morning, everyone. My name is Linda Coleman. I practice with the law firm Spears, Carlson & Coleman here in Washburn, and we also are corporation counsel for Bayfield County. It's very exciting to be here today for everybody in the county, and it's really exciting to see a lot of students here, too. This is potentially once-in-a-lifetime experience. So I am here to introduce the first case, the case you'll be hearing about this morning, which is State v. Maddox. Now, this is a criminal case out of Waukesha County. Because it's a criminal case, the plaintiff is the state of Wisconsin. The defendant in the case is Roderick Maddox. He was convicted of first-degree reckless homicide for allegedly delivering heroin that ultimately caused the death of a man named Samuel Luke. Mr. Maddox was originally tried at a bench trial, which means a trial not before a jury, but before a circuit court judge. And the circuit court judge, at the close of trial, did find him guilty. At the trial, Dr. Okia testified. Now, Dr. Okia was the medical examiner who performed the autopsy on Mr. Luke's body. According to her testimony, the autopsy she performed, as well as evidence found at the scene where Mr. Luke's body was located, led her to believe that Mr. Luke died from a drug overdose. But she also testified that she relied in part on laboratory results to help determine that the cause of death was acute heroin intoxication. And these laboratory results are really at the heart of the issue that the court will be hearing today. During this bench trial, this trial to the circuit court judge, the defense objected to Dr. Okia's testimony about the lab results. The results had been processed at a lab at St. Louis University, and nobody from that lab was at the trial to testify. The defense argued that Mr. Maddox, the defendant, had a right to have a lab analyst, the lab analyst from St. Louis University, present in court to be cross-examined, or in other words, for the defendant's counsel to be able to ask questions. The circuit court judge overruled the objection, which means that the judge disagreed with that objection and allowed Dr. Okia to testify about the lab results. The court received the report into evidence, quote, for the limited purpose of being part of the basis upon which Dr. Okia rendered her opinions. The defense appealed the conviction of Mr. Maddox to the Court of Appeals for District 2. The basis of that appeal was the Sixth Amendment to the Constitution. Now, the Sixth Amendment to the Constitution guarantees a defendant in a criminal trial the right to confront his accusers. The defense argued that that right was violated when the circuit court accepted a toxicology report into evidence without giving Mr. Maddox the chance to confront anyone from the lab who prepared that report. Rather than ruling on that case, the appellate court certified it to the Wisconsin Supreme Court, the court you'll be hearing today. In other words, they referred the case to the Supreme Court in order for the Supreme Court to make a decision. This means that the Court of Appeals identified an issue in this case that it felt should be addressed by the highest court in our state. The Court of Appeals indicated that it certified this case because it wanted a, quote, definitive and controlling ruling, unquote, in Wisconsin regarding whether and under what circumstances a criminal defendant has the right to cross-examine a laboratory analyst when a toxicology report is introduced into evidence. This is something that comes up in a variety of cases. One of them certainly is a case like this, but another you could imagine would be an operating while intoxicated case where somebody's blood sample is taken at the scene and sent to a lab for analysis in order to determine what a person's blood alcohol content is. So this issue is something that the appellate court said is an important issue, and the court that should make a decision is the Supreme Court of our state. Now, there's good reason why the appellate court felt there was a need for a definitive and controlling ruling on this issue. This is not the first time a court of appeals in our state has wrestled with the question of whether the Sixth Amendment prevents the prosecution from introducing evidence from a toxicology report without having the lab analyst involved actually present at trial. And, as it turns out, the Wisconsin appellate courts that have addressed this issue have come to different conclusions. Bear with me, I'm going to mention just a couple of cases that you're probably going to hear mentioned as you listen to oral arguments today. One is State v. Hine. This was a case decided just in 2014, so pretty recently. That case also involved a defendant who was convicted of reckless homicide due to the delivery of heroin. Just like in the case you're going to hear about today, a medical examiner testified in the Hine trial, and the court admitted into evidence a toxicology report that was prepared from a different separate lab, and nobody from that lab testified at trial. Now, in that case, the appellate court held that the introduction of the toxicology report was acceptable, was allowable. State v. Van Dyke is another case you might hear mentioned today, and that was decided just a year later, in 2015. Very similar circumstances to this case again. There's a reckless homicide conviction related to the delivery of heroin, and a medical examiner testified about the contents of a toxicology report that he did not prepare himself. In that case, the appellate court found that the testimony of the medical examiner about the report did violate the defendant's Sixth Amendment right to confrontation. So you've got two cases decided just a year apart with very different results. There are some differences between the facts and testimony involved in the Hine case and the Van Dyke case, and you might hear about some of that today. But I think you can see that these two rulings do create some tension about what is or is not permissible under the Sixth Amendment in these types of cases. Add on to that tension the fact that the Supreme Court of the United States has also ruled on cases having to do with a criminal defendant's Sixth Amendment right of confrontation. The Supreme Court of the United States, of course, is the supreme judicial body in our nation. And their decisions create precedent that all courts are bound by or have to follow. So you're likely to hear reference today to some Supreme Court cases, as well as the Wisconsin cases I mentioned. The defendant in this case argues that the medical examiner should not have been allowed to introduce the toxicology report and testify about its contents, because the lab analyst who created that report did not testify at trial. The defendant argues the medical examiner relied on that lab report to determine the cause of death, a heroin overdose. So the contents of that lab report were important. The defendant argues that once the state chooses to introduce a toxicology report, the defendant has a constitutional right to confront the analyst who actually prepared it. The state, for its part, argues first that the primary purpose of the report was to help determine the cause of death, and there were many factors relied upon by the medical examiner in reaching her ultimate conclusion about the cause of death. The toxicology report identified the raw numbers in terms of the substances present in the victim's samples, but according to the state, the medical examiner, quote, applied her own substantive expertise, unquote, to interpret those raw numbers and form her ultimate conclusions. Lastly, and this is important, according to the state, the cause of death was not really important in this case. And the defendant did not really dispute that the victim had died from a heroin overdose. The real dispute, according to the state, was over who had supplied the heroin the deceased man had ingested. Thus, even if the introduction of the toxicology reports was in error or wrong, the state argues that that error was harmless and did not affect the court's ultimate ruling that the defendant was guilty. Given the uncertainty created by the recent string of cases dealing with the right to cross-examine a lab analyst, and given that the appellate court felt these issues will recur in many future cases, the Wisconsin Supreme Court agreed to accept certification of this case. If the defendant prevails, and this court determines that evidence of the laboratory analysis should not have been introduced at trial, unless someone from the lab that produced the report had testified in person, then the defendant will be entitled to a new trial. If the state prevails, and this court determines that it was okay for the laboratory results to be discussed and introduced into evidence by the medical examiner, even though she did not conduct the analysis herself, then the conviction of Mr. Maddox, but that introducing that report did not change the outcome of the trial. In other words, this court could find that the defendant is correct, and he had a right to confront a laboratory analyst at trial, but that even if the lab report was not introduced into evidence, the defendant would have been found guilty in any event. In that case, the conviction of the defendant could be upheld despite the error by the circuit court in admitting the lab report into evidence. Now, sometimes the Wisconsin Supreme Court has to address a matter of first impression, or a matter that hasn't been addressed by lower courts before. In this case, the court will be addressing a matter that has been heard by quite a few other courts. But the resulting rulings have created a lack of clarity in the law in Wisconsin. The decision by the Wisconsin Supreme Court in this case may create certainty on this issue and serve as a guide for all such cases in Wisconsin going forward.
Thank you, and may it please the court. My name is Leon Todd, and I represent the defendant appellant Roderick Maddox. The issue in this case is whether it violates a defendant's right of confrontation for the state to introduce the following two pieces of evidence at trial to prove that a decedent died as a result of a heroin overdose. One, the toxicology report of a non-testifying laboratory analyst, and two, the opinion testimony of a medical examiner who relied on that report to conclude that the decedent died of a heroin overdose. The answer to that question is an emphatical yes. The introduction of both those pieces of evidence violated Maddox's right of confrontation. The toxicology report was barred by the Confrontation Clause because it was a testimonial out-of-court statement, and the cause of death opinion of the medical examiner was also barred by the Confrontation Clause because she served as a mere conduit for the report's testimonial conclusions. And because of these constitutional violations, this court should reverse Maddox's judgment of conviction and remand this case for a new trial.
Counsel, why do you think this was testimonial, which is foundational to the confrontation issue? Why is this the toxicology report testimonial?
It's testimonial under the precedent of various different courts. It's testimonial according to the United States Supreme Court's primary purpose test. It's testimonial according to Wisconsin case law, specifically State v. Van Dyke. And it's testimonial according to the majority of federal circuit courts of appeal and other state Supreme Courts that have addressed this issue.
What makes it testimonial? That's perhaps a better framing of my question.
Sure. What makes it testimonial is that its primary purpose was to establish or prove past events that are potentially relevant to a later criminal trial. The primary purpose of the toxicology report was to prove a past event, the past event in this case being whether Mr. Luck died as a result of a heroin overdose.
Mr. Todd, how can you tell that was the primary purpose for this test?
The toxicology report is specifically searching for the presence and levels of contraband substances in Mr. Luck's system at the time of his death. It has no other purpose than to determine the presence and levels of those drugs, and the only reason for doing that is to know whether or not he died as a result of a heroin overdose. This is a death investigation in which the medical examiner is searching for cause of death. It's a suspected homicide.
Mr. Todd, I think that answer feeds into the question of whether this was whether the doctor here was acting as a simple conduit for the results of this test. The test results simply measured the quantity of certain substances in the blood levels. Is that correct?
The presence and the levels, yes.
Okay. And then the medical examiner's testimony was what?
She testified to a number of different things. She testified to the specific results of the toxicology report and the meaning of the toxicology report. She also testified about her autopsy and her physical examination of the body, and she gave her opinion as to cause of death.
All right, so let's focus on that for just a moment. Does the toxicology test result state the cause of death?
It doesn't state it specifically.
Does it contain any reasoning that would lead a reader of the report to come to the conclusion that the cause of death was heroin overdose?
Absolutely it does. It contains a conclusion that Mr. Luck's blood contained fatal levels of morphine and the presence of 6-MAM, which is a metabolite that's specific to heroin.
Well, and perhaps, forgive me for, I want to be precise about this. Mm-hmm. Did the toxicology report say that the morphine levels were fatal, or did it simply measure the amount?
It measured the amount.
Okay, so it didn't say it was fatal?
It didn't use the word fatal.
All right. And would a layperson reading this report be able to come to the conclusion that the toxicology report says that the cause of death is heroin overdose?
I'd have to say no.
Okay, so it would...
it's possible they could, but more likely than not, no.
All right. So more likely than not, it would require someone with the medical examiner's training and experience to look at the toxicology report and interpret that data to come to a conclusion.
That's correct, but that's no different than the situation in GREEP when, State v. GREEP, when the surrogate lab analysts still required qualifications, training, and expertise to review the raw data and the gas chromatograms and the notes and the test procedures. It required expertise to review that and determine and come to an independent opinion that the defendant in that case had a blood alcohol level above a certain amount. In this case, though, the medical examiner didn't review the raw data. She didn't review anything other than the report itself and accept it at face value. And the conclusions in the report were absolutely necessary for her to draw the conclusions that she did. It was a conclusive basis for her opinion. There's no indication in the record that she could have concluded without the toxicology report that heroin was the specific drug that caused Mr. Luck's death. And there's no indication that she could have even concluded that his cause of death was a drug overdose in general. For all we know, it's possible without the toxicology report, the medical examiner would have had to say cause of death is unknown in this case.
Counsel?
Yes.
I'm glad you mentioned GREEP. I'm curious, do we have to change anything in GREEP or in Deadwiller? Those are fairly recent court cases, so talk to me about that. If we rule your way, do we have to change our precedent at all?
If you rule in my favor, in Mr. Maddox's favor, GREEP will not need to be changed. I think if you rule in the state's favor, though, that would require overruling or at the very least modifying GREEP. What GREEP held was that an expert can consistently with the confrontation clause offer an independent opinion based in part on the work of another expert. but it also recognized that one expert can't simply serve as a mere conduit for the opinion of another.
So the testifying witness had to be an expert who used his or her own expertise.
That's part of it, yes. To ensure that experts don't serve as mere conduits, the court in Griep held that an expert who relies on the testimonial conclusions of another expert has to, one, review the test and the work of the other expert, including such things as the notes, the graphical data, and the other records that are associated with the whole analytical run. And two, they also have to form an independent opinion. They can't just parrot what's in the conclusions of another report. And the other thing that Griep established is that the expert has to be familiar with the testing procedures at hand at the laboratory of the non-testifying laboratory analyst. And in this case, Dr. Okia's opinion satisfied none of those criteria.
What about Deadwiller?
Well, I think Deadwiller is consistent with Griep and reiterates the principles in that case.
So we'd have to change that as well if we rule for the state?
I think that that's true. The standard and principles of Griep would have to be altered or modified. In this case, Dr. Okia, she was a medical examiner from Waukesha. She's not a toxicologist. There's no indication that she was otherwise familiar with the testing procedures at St. Louis University, and she didn't review the notes or the graphical data or any of the other records associated with the toxicology report, and she didn't form an independent opinion about the presence or levels of morphine in 6-ma'am in Luck's system at the time of his death. She simply took the results of the report, the conclusions, accepted them at face value, and used them to form her cause of death opinion.
Can you talk to me a little bit about the defense that was presented here? Was there any dispute that this was a heroin overdose?
Well, the state presented the toxicology report and the testimony of the medical examiner in order to prove that the decedent died of a heroin overdose. The state or the defense didn't contest it, but in large part they were unable to contest it because they didn't have the opportunity to cross-examine the actual toxicologist that did the report.
But what was the defense here? I'm sorry.
Well, the defense at trial was that Maddox did not deliver the heroin that was used by Mr. Luck. But if the toxicologist from the laboratory would have been required to testify as he should have been, the defense may have been different. Because the laboratory analyst who did the test didn't testify, we know literally nothing about the toxicology report or the work that generated it. We don't even know what type of test this analyst used. We don't know if it was accepted by the scientific community or if it's junk science or discredited forensics. We don't know if it was peer reviewed. We don't know if it was machine generated. We don't know what the error rate of the test is.
Counselor, wasn't it also true that there were needles and syringes and a little cooker pan that tested positive for heroin that were all found next to the young man when someone discovered his body, and that someone from law enforcement came in and did collect all of those items and send them for testing too?
That's true.
So it really wasn't a contest about whether he died of a heroin overdose or an overdose of some other substance, correct?
Well, it wasn't a contest because the state was allowed to introduce the toxicology report and the opinion of the medical examiner. If those things hadn't come in, I think it would have been contested. The things you mentioned regarding the drug paraphernalia in the room, the track marks on his arm, those are certainly consistent with the theory that he died of a heroin overdose. But I don't think that any reasonable fact finder could conclude from simply that type of evidence, the fact that there's a dead body and that there's heroin paraphernalia in the room. I don't think
he had 13 puncture marks in his arm. Most folks don't carry those numbers of puncture marks in his arms. Didn't you think that was tied to a possible drug overdose?
Possible. It's consistent with that theory, and it's certainly a possibility, but it's also a possibility that he died of natural causes. It's also a possibility that he overdosed on the clonazepam that was also found in his room. His sister did tell the medical examiner and the detective that he was suspected to have abused that drug as well. Those things are possibilities. And I don't think that any reasonable fact finder could conclude beyond a reasonable doubt simply from those type of things that he died as a result of a heroin overdose without speculation or conjecture. I think that type of testimony really, or that type of finding by a fact finder really requires expert medical testimony as to cause of death that's based, or that's held to a reasonable degree of scientific or a reasonable degree of medical certainty. And in this case, that didn't happen. So,
would you have been more comfortable if a medical book that was submitted in advance as being sound legal theory that talked about when you have 6 MAM in body fluids that is dispositive of ingestion of heroin at a prior time?
You know, that's an interesting point because, and I think that just goes to my point that the medical examiner was just a mere conduit for the testimonial conclusions in the toxicology report. Because if you can glean the same conclusion from a book that interprets the meaning...
Well, I couldn't. I'm not a physician. Doesn't it take a bit more knowledge than just reading the book and the numbers?
It may or may not, but I think the real point is that without the toxicology report and the conclusions in that report, you know...
But the conclusions are just numbers, correct? There's not a statement in there that 6 MAM is indicative of ingestion of heroin at a prior time, correct?
Going back to Justice Kelly's point, it doesn't use the word that this is a fatal level. It doesn't say that 6 MAM is specific to heroin. But it is more than just numbers. It's a conclusion that Luck's blood, urine, and tissue samples from injection sites, it categorizes them. It says what drugs did he have in his blood? What drugs did he have in his urine? What drugs were in the tissue samples from the injection sites? And it lists a number of different drugs. It also excludes a number of different drugs. And it concludes that, you know, there was a specific level of heroin, a specific level of morphine and a specific level of 6 MAM. And it also asserts that those samples belong to Luck, without any other chain of custody evidence to substantiate that.
But wasn't it the doctor's testimony that she based her conclusion that he'd ingested heroin in the past based on the products that were in his blood that are there after heroin has at least started to be metabolized or perhaps fully metabolized in the blood? She didn't base it on the report. The report, she said, were just numbers.
I think she did base it on the report, and I think...
Yeah, she said based on her independent medical knowledge. I mean, I have the transcription. I'm sure you've read it too.
She does say based on her independent medical knowledge, but she could not have concluded that without the toxicology report. It was a necessary basis for her to reach the conclusion that she did. Okay. And I don't think it's fair to say that her cause of death opinion was made independently because she doesn't generate her autopsy report until after she receives the toxicology results. And in the factors which she notes the factors that she notes that support her conclusion, she lists the specific levels of morphine and 6 MAM that are in the toxicology report. She lists those first in the factors that she lists when she's the relevant factors to determine cause of death. And there's no indication that she concluded that heroin was the specific drug that caused his death prior to receiving the results of the toxicology report. And there's no indication that she would have been otherwise able to conclude what the cause of death was without this toxicology report.
Okay, thank you.
Mr. Todd, let's assume that we accept your argument that this is testimonial and that it violates the Confrontation Clause. I'm interested in what your limiting principle is on this argument. Here's what I mean by that. So we have a toxicology report. It identifies a certain amount of chemicals in bodily fluids and tissues. Presumably, the way that number was derived was that there were lab technicians that used certain equipment to test the biological specimens. Would we then have a confrontation clause problem if we did not, if the state did not present someone to testify about the lab equipment that was used to derive those measurements, so that we could be certain that the result of the testing was accurate in light of the equipment that was used?
Well, I think you need if I understand your question, you would need testimony from the person that conducted the test. Presumably that's the same person that generated this report. But I think you need the author of the report, the person that does the test, and you also need someone with firsthand knowledge that the machines are in good working order.
And what manner of person would be competent to give that kind of testimony?
A person who has training and experience in administering those tests, toxicologist.
All right, so the state would need to bring in the person who performed the lab test. They'd also need to bring in the person who presumably maintains the equipment used to perform the lab test.
Well, I think they would need some evidence that it's in good working order. It could be a certificate or something like that, but I think at a minimum you need the person that did the test and authored the report.
Well, if it's a certificate, wouldn't that be testimonial with respect to the good working order of the equipment?
Perhaps, but I think you need someone from the laboratory that's able to testify intelligently about the test that was performed. And I think, I don't think this is an insurmountable burden for the state.
What about a supervisor of that person? That's Greek, isn't it?
I think that would be acceptable under GREEP, yes, that's a good point.
You know, you have two problems as I see this case. One is who can testify when you got someone who does the lab work and then someone comes in and testifies, or you have no one who testifies as to the lab work. Here you do have someone who is relying on it. That's your confrontation clause, right? The United States Constitution says you have a right to confront.
Yes.
Any witness against you, right?
That's correct.
And the state constitution is something similar, right?
Yes.
And so that goes all the way back to the founding of this country. If somebody's going to accuse you, they gotta look you in the eye and tell you, and you have a right to question them.
Absolutely.
Right, and that's your first point. And your second point, which came, I think, out through questioning, is, okay, no one ever gets a perfect trial, isn't that right? Because we're all humans and there's bound to be at least one mistake somewhere, right?
Could be.
That's
yes.
right. And that's not going to tip over the conviction, right? A mistake.
I guess it depends on the mistake.
That's right. That's my point. But there probably is never a perfect trial because it's all done by humans and we probably have made a mistake. So you have to have a serious mistake, right? And even if there's a mistake and that this medical examiner should have been cross-examined, the conviction can still be upheld on the doctrine of harmless error. And the state spends a lot of time talking about harmless error. And there are a lot of people who call this court the court of harmless error. So you fix up the mistakes by saying it wasn't serious enough to tip over the conviction, right?
I think in this case it absolutely was serious enough to tip over the conviction.
Okay, tell me why.
One of the essential elements the state had to prove was that not only that Maddox delivered the heroin that was used by Mr. Luck, but that Luck used that heroin and actually died as a result. The only pieces of evidence in this case that actually prove that Mr. Luck died of a heroin overdose are the toxicology report and the opinion testimony of Dr. Okia, who relied on that report to form her conclusion that Mr. Luck died as a result of a heroin overdose. Yes, there's other evidence that's consistent with that theory, but again, I don't think any reasonable fact finder could conclude from things like the fact that there's drug paraphernalia in a room or that a person has track marks on their arm. I don't think any reasonable fact finder can conclude from that type of evidence that Mr. Luck died as a result of a heroin overdose without guessing. They're guessing that it's heroin. It could have been natural causes. It could have been an overdose on another drug. We don't know that. So I think it was absolutely a significant error in that sense, and it was not harmless error. And it's also a constitutional
What's the
error.
test for harmless error?
The state has to prove beyond all reasonable doubt that the verdict would have been the same if Maddox's confrontation clause objection would have been sustained, and then as a result, the trial court would have excluded the toxicology report, excluded all testimony describing or based on that report, and excluded the cause of death opinion of Dr. Okia that was based on that report.
It sounds like this court becomes the trier of fact and the trier of guilt. And that's not what the Constitution says. The Constitution says you have a jury of your peers.
Well, I think this court needs to decide if this was a constitutional violation. I think that's a very significant question, and we need clear guidance in Len Bias homicides on what the rules are. And
in this case, it was a court trial, and thank you for that,
That's
because
still
I was
the
going to
trier of
ask you,
facts.
does that make any difference?
It makes absolutely.
Would there be any other remedy? You know, because the judge who actually decides guilt or innocence is the judge that would decide what the evidence could be or not be, and so this judge is going to know all of this.
I don't think it makes any difference whether or not it was a jury trial or a bench trial. Regardless of who the fact finder is, the state still has the burden to prove Mr. Maddox's guilt on every element of the offense beyond a reasonable doubt. And at this level of the proceedings, they have a similar burden to prove beyond all reasonable doubt that the verdict would have been the same if the trial court had excluded those pieces of evidence that I just mentioned. And I don't think they can meet that burden because, one, there's insufficient evidence just as a matter of law on the element that Luck actually died as a result of a heroin overdose without that evidence. And certainly at a minimum, a reasonable fact finder could have rejected the state's case and said, you didn't prove your case. You didn't make it in this one. You didn't prove that he actually died as a result of a heroin overdose beyond a reasonable doubt.
Mr. Todd, I'd like to give you the opportunity, I'd like to have the opportunity to follow up on an argument you started to make several minutes ago, and that was, you started to say, well, gee, we don't know that this testing method is even something that's accepted within the scientific community. Does the record disclose that the state followed or did not follow the applicable statutes in regard to disclosure of anticipated expert testimony, including the basis for the expert testimony?
I don't think the record discloses that they did it with regard to the toxicology report.
Well, is there any allegation made that they didn't?
I'm sorry, I'm not sure I understand your question.
Is there anything to indicate that the state did not follow their duties under the discovery statutes for turning over all of the reports that the expert witness was going to rely on?
I'd have to look at the exact requirements, but...
Let's take it out of this case and say, in the normal course of events, the defense, and your red light is on. What I'd like to do when you come back for rebuttal, your red piece of paper is on. When you come back for rebuttal, because we try to respect the red, in this case, paper, when you come, I'd like to explore the idea that the defense would have or would not have had the opportunity to have challenged that in pretrial motions, and that would have been the more appropriate venue if concerns were raised in regard to the any kind of standards of scientific acceptability for the testing method used. Okay?
Yes, Your Honor.
Thank you very much.
Thank you.
For those of you that are sitting out in the audience, I'm not sure how much our marshal explained. I know the lawyers know what they're doing, but just so that the public knows what the lawyers are trying to follow from our marshal, we give each side 30 minutes so that we treat them both alike to make their arguments. They get a green card that our marshal shows them, and the lawyers have to kind of keep track of it, to begin. Then 5 minutes before they're going to be shut down on their 30 minutes, they get a yellow card, and the marshal puts that up. And then when it's time not to talk any longer, they get a red card, which means it's time for them to sit down and the other side may have a shot at giving a presentation. So now that you all know, if you happen to see what our trustee Marshall is doing over there, you'll know why she's changing the cards around.
Chief Justice, if I may, in Madison, it's done with the similarly colored lights, hence my comment in regard to lights.
Yes, very good.
I'm not hallucinating, which some of my critics would say is a step up.
Okay, are you ready to proceed with your presentation?
Luke Berg for the state of Wisconsin. May it please the court. There are three different reasons that the state wins this case, but the simplest is that the toxicology report at issue is not testimonial because its primary purpose was to determine cause of death, not to create an out-of-court substitute for trial testimony.
What is the indicia of testimonial under Bull Cummings or?
So I think this is really important, and the first thing I wanted to talk about is the test, because I think there's a disagreement between the parties. The court has used a lot of different phrases to describe the test.
Which court are you talking about?
The Supreme Court, the United States
US
Supreme Court. Yes.
Okay, thank you.
Has used a lot of different phrases. Everyone agrees, we all agree, that you look to the primary purpose of a statement, but then the question is primary purpose to what? And the court has used a lot of different phrases to describe the to what. So I'm going to rattle a few of them off because I want to give you a sense of what those phrases are. So the court said to create an out-of-court substitute for trial testimony. That's from Bryant and Clark. To obtain testimonial evidence against the accused. That's also from Clark. To establish evidence for the prosecution. That's also from Clark. To create a record for trial. That's from Bryant. To produce evidence. That's Melendez-Diaz. To produce evidence for use at trial. Also Melendez-Diaz. To establish or prove some fact at trial. Also Melendez-Diaz. To provide a weaker substitute for live testimony at trial. Also, that's Davis. So as you can see, all of these phrases have the same gist. The purpose has to be to produce evidence. Now, the one phrase that I think can be misunderstood comes from Davis, and that's the phrase that the other side relies on, and that is to establish or prove past events potentially relevant to later criminal prosecution. Now, the danger with that phrase, the reason it's misleading, is it can be ripped into two parts. That's not how the court has applied it, but that's how Maddox is applying it. So you take the first part and say the primary purpose has to be establish or prove a past event. That's definitely true of a toxicology report. And the second part is that past event is potentially relevant to a criminal trial. That's also true of a toxicology report. But you can't pull that phrase into two separate parts. If you did, the outcome in Davis itself, where that language come from, would be different. In Davis, you had some statements made to a 911 operator. Clearly, the primary purpose was to establish a past event, what happened, who did it, and those events were potentially relevant to a criminal trial. So you can't split that phrase in two. You have to understand that phrase from Davis in light of all of the other phrases that the Supreme Court has used. And so the test ultimately, I think, that the court landed on in Clark, the most recent case in this area, is whether the purpose was to create an out-of-court substitute for trial testimony, whether it's evidentiary. I think it's very clear that autopsy and toxicology reports do not have that primary purpose. Their primary purpose is to determine cause of death.
Is there anything in the record to reflect that the laboratory who conducted this testing was aware of the reasons that the samples were sent to them and why the testing was requested?
That's very important.
And does it matter?
That's a very important question. Yes, it does matter. The only thing that was told to the toxicology lab was that the victim, Luke, was found unresponsive at home. They were given some samples and asked to test for various substances, not just illicit drugs. They were also asked to test for a variety of legal substances like alcohol, Tylenol, antidepressants. So from the perspective of the toxicology lab analyst, they would have no reason to think that the reason they were creating this report was to produce evidence for trial. For them, it was a routine lab report. They were just running some samples through in order to determine cause of death.
And to what extent does the record reflect the medical examiner's awareness of a potential criminal investigation surrounding the death of this young man?
So there were some indications that Luke had died from a drug overdose. So obviously there were the puncture marks in the arms. There was a syringe found. The police were aware that Luke had a drug problem. But that's sort of the extent of it from the medical examiner's perspective. So before the lab was done and before the autopsy was done, Luke could have died from any number of circumstances. It could have been an entirely natural death. It could have been a heart attack, an aneurysm. It could have been a suicide. It could have been an accident. For example, poisoning by some toxic combination of substances. He could have overdosed or injected some legal substance, such as a pharmaceutical. He could have overdosed on alcohol. And even if the medical examiner knew in advance that it was a heroin overdose, she didn't, but even if she did, that doesn't necessarily mean that a crime had been committed. It's possible that Luke had manufactured the heroin himself or stolen it from somebody. And furthermore, the crime that we're talking about, which is delivery of a controlled substance that causes death, is not like a brutal murder where it's almost guaranteed that there's going to be a criminal investigation and charges.
And if I understand the context of your argument and the first part of your responses to your colloquy with Justice Rebecca Bradley, Justice Ann Walsh Bradley had started to make reference to Bull Cumming versus New Mexico. And I think you're arguing here we have the opposite or the converse situation where in Bull Cumming it was determined that all of the toxicology tests were done at the direction of law enforcement for the specific purpose of law enforcement, for the specific purpose of detection of criminal conduct. Here you're saying this does not fit within the prescriptions of Bull Cumming for the reasons that you've just articulated, I think.
Yeah, that's exactly right. But there's an additional point that's really important from Bull Cumming. And that is Bull Cumming, Melendez-Diaz, Greep, and Williams. All four of those cases involved either a test of a substance to see if it's drugs, so I'm testing substance to see if it's cocaine, or a blood alcohol test. Those tests have no purpose other than an evidentiary purpose. The only reason you would run one of those tests is if you want to produce evidence at trial. And Justice Sotomayor in Bull Cumming, in a concurrence, emphasized this specifically. She said, we're talking about a test here that is solely evidentiary. The state hasn't given any alternate purpose, much less even a primary purpose, that's otherwise. And so toxicology reports and autopsy reports are totally different. They are not generated primarily to produce evidence.
Mr. Berg, I want to give you the opportunity because I've obviously tipped my hand into an area of inquiry that I'm interested in, which is Mr. Todd had started to make the argument that we do not know about the scientific reliability of the test. It could be something that's not accepted within the scientific community. I've given him the forewarning that I'm interested in hearing about it in his opportunity for rebuttal. You heard that exchange. What are your observations? What are your comments in regard to his argument in that regard?
I think this raises a very important point, and that is that we need to keep in mind that the confrontation clause isn't the only tool to deal with these sorts of problems. State rules of evidence still apply. So the one that you referred to where the state has to turn over evidence in advance and the defense has an opportunity to review it and consider whether there was a problem with the toxicology report. The defense could subpoena somebody from the toxicology lab if there was some evidence that the lab was really bad or the analyst himself made mistakes all the time. They could put that evidence on in their case.
Well, there are specific statutes in regard to what the state has to turn over in advance and dictating how long in advance it has to turn it over in regard to expert testimony, right?
Yeah.
And including a summary of the anticipated testimony and what the expert is going to rely on.
Right.
Is the record silent here as to whether the state turned over all these documents?
That's not something that I focused on, so I can't say definitively what the record says about that. But there's no indication that I have seen in the record that the state didn't comply, and there's no allegation that they didn't comply with all of those requirements.
If they did comply with all of those requirements, would that excuse a confrontation clause violation?
No, if there was actually a confrontation clause problem, I don't think so, no. But there isn't here because the report is not testimonial.
But the matter could have been sorted out in something like a pretrial motion.
Yes, I think the important point, though, is that the confrontation clause isn't the only tool to deal with these sorts of problems. There are other ways. So the confrontation clause deals with a very narrow subset of these types of problems when you actually have a statement that is testimony, that is equivalent to a witness against the accused. And so that's why we can feel comfortable with drawing some limits on the confrontation clause, because we know that there are other sort of backstops to protect against the type of problems that they allege may or may not have happened.
Counsel, I want to get your take on a concern that was raised in the certification by the Court of Appeals. They certified the case to us rather than addressing this case as they do in the normal process of an appeal. And I'm looking at page 20 and 21. In essence, of the certification. In essence, they indicate that our view, Court of Appeals view, of the confrontation clause as expressed in Hine and Van Dyke appears to be in conflict with the view of the United States Supreme Court in Melendez-Diaz and Bullcoming. And the reason for that, they say, is this. Okia's testimony appears to have provided, quote, merely a recitation of another's conclusion. That there was no personal knowledge of forensic tests. And some cases say as long as the witness's opinion is reached independently and is not merely a recitation of another's conclusion. Okia herself was only in a position to, and did, simply assume that those results were correct. This appears, however, to also have been the case with the testifying medical examiner in Hine and Van Dyke. That's what they're referring to, the need for independence. So what do you think about the Court of Appeals asserting that its view in those cases, as expressed in Hine and Van Dyke, appear to be in conflict with Bullcoming and Melendez? Do you agree or disagree?
I disagree. Hine and Van Dyke applied this court's test from Griep, and this court did a very careful review of all of those cases, Bullcoming, Melendez, Diaz, Williams, and I think concluded correctly that the Supreme Court hasn't ruled out independent opinion testimony that relies on testimonial statements. And so the test from this court is an expert who provides an opinion, providing an independent opinion, or is he or she a mere conduit of somebody else's statement? That language, that mere conduit language, actually I think the Supreme Court noted it approvingly in Williams. One of the opinions did, I can't remember which one. So there's no, I think it's pretty clear that this court's test is not inconsistent with the Supreme Court.
Let me take a look at the actual findings then of the medical examiner here. And as I look at the medical examiner's report, there were 5 or 6 findings, A through E or F. And at least half of those findings were explicitly, it appears to me, taken from the toxicology report. So isn't that, or the argument is advanced, that at least half of those findings, if not more, I can take a look at it and be more specific, at least half of those findings are specifically taken and just repeated from the toxicology report. I'm looking at Exhibit 17, the Waukesha County Medical Examiner's Office autopsy report, Appendix 195 and 196, and it's 196 that I'm referring to. Indeed, there are findings 1, A through F, and then finding 2. And findings 1, A through at least D, the 4, appear that they're just reciting the toxicology report. So can you help me with that?
Yeah, this court in both Griep and Williams has said explicitly that experts can rely in part on the statements of others. The test is whether it's in part or whether they are just a mere conduit for someone else's opinion. The mere conduit is sort of the catchphrase for the whole test. I think there's no way you can say that Dr. Okia's opinion testimony as to cause of death was a mere conduit because the report that she is alleged to be a conduit of doesn't draw the conclusion. It doesn't say anything about cause of death. It doesn't say what any of the levels mean. It doesn't say that 6-monoacetyl morphine is specific to heroin. So clearly she had to apply her independent expertise, and she had to combine the results from the autopsy in order to draw an opinion as to cause of death. So it's clearly independent, I think. But remember, you don't even get to this question until you first decide that the toxicology report is testimonial. So if you decide the toxicology report is not testimonial, then this whole second issue becomes irrelevant.
You were arguing about, and I asked earlier about the indicia of testimonial. You focused on the primary purpose. What role, if any, does the formality of the document itself have as an indicia of testimonial?
Formality is one factor in the test, basically, that the court has relied on. That's what they've said.
Does this report meet the formality part of the test?
No, it doesn't, because it doesn't certify that the statements in it are true. That's the formality that Justice Thomas, who really cares about this factor, that he talks about frequently, that it has to be sworn like an affidavit certified that I certify that everything in this report is true, is accurate, as you would do in an affidavit. Here, it's simply signed.
Is that the majority opinion of the court with regard to the formality analysis?
The majority sort of treats the formality analysis last. It doesn't spend a lot of time on it because they only view it as one factor, not as the test.
They include the title, if I recall, as one of the many.
Right. Yeah, but I think the most significant facts with respect to formality is how much does this look like an affidavit or the type of stuff that you would put into evidence in a case. And yes, this is signed. Yes, it has a title. Yes, it has a name, but it's not certified. It's not sworn. So no, I don't think the formality rises to the level of a testimonial statement.
I have a more global issue. And although we may not have a lot of drug cases that raise the issue here of who supplied the drug that caused the death, there are a lot of drug cases. There are a lot of other cases that require expert reports, right? So this concept of bringing in reports from the state lab or from private labs runs throughout probably the whole criminal justice system in all the counties, right? Okay. And with the Crawford case from the United States Supreme Court, which was in 2004, that was a sea change. You agree with that?
Yeah.
Okay. And so now we are in our 12th year of Crawford, right? Crawford, AC, after Crawford, 2016. And we got a number of U.S. Supreme Court cases. Bullcoming, Melendez, Michigan v. Bryant. We can go through them. And then we got several Wisconsin cases, many of whom have been named. And we're going to get more cases, right?
Yeah.
If not in October, maybe November and thereafter, right?
Right.
And how much, I'll put it positively, an enormous amount of time has been gone into determining, is it testimonial, isn't it testimonial, can it be used, is it a violation of confrontation, etc. And we don't have clear answers, and the primary purpose test is not a clear answer. We get primary tests coming out of the gazoo in civil cases too, and we can't figure that out yet. Here we have it, and we've got several definitions. So it seems to me that what we need here is a solution that fits the Wisconsin Constitution and the United States Constitution and tells the trial courts as best we can, as bright line as we can, what we should be doing here so that we don't spend enormous amounts of time and effort by lawyers, trial courts, Court of Appeals, and this court in dealing with this. And that's what I'm looking for. And what's your resolution? You are with the, it's a relatively new office in the state. You're with the Department of Justice, but you're Deputy Solicitor General. I think the way this is running now, every case that comes here is going to be handled by you.
Not me, one of my colleagues, yeah, right.
And will take over the criminal justice system in the Department of Justice. So what's your solution?
I think,
don't tell me primary purpose because I don't understand it. No one else does either.
I think the point you raise is a very important one, and I think that's why we briefed and argued the case the way that we have. What we would like this court to hold is that autopsy and toxicology reports in general are not testimonial.
Well, now you've just ruined it by saying in general. What does that mean? Not primarily.
There will be...
Come on.
There will be rare circumstances where in general will not be met. So
Okay,
I'll give you an example. The state has a system called an inquest. That's a court-ordered proceeding. A jury sits, six-member jury, and the inquest is to determine cause of death. A district attorney can order a medical examiner to conduct an autopsy.
Not very usual, but they're not.
So they're rare, right? If
well,
in that situation,
they're in between.
In that situation, I think the medical examiner conducting an autopsy under an inquest, a court-ordered proceeding, would clearly have a primary purpose of producing evidence. It would not be simply to determine cause of death. So that's an example of an exception, but I think in general, in the vast majority of cases, most autopsies and toxicology reports will not be testimonial. And here's why. I mean, something we don't think about often is medical examiners, but medical examiners actually conduct a very important function in our society. It's important that every death is certified and reported.
Is that a coroner, the old-fashioned coroner?
Yeah.
Okay.
Yep. So it's important that every death is certified and recorded. Now, oftentimes it's the doctor or the hospital that does it, but
and
in many
if
times...
that's the way it's done, there is no medical examiner.
That's
They
right.
Sign off.
That's right. But many times that's not possible. Right. So if there's somebody dies at home, there's an accident or a suicide, or for whatever reason the doctor is unwilling or unavailable to sign the death certificate, then the medical examiners step in and sort of fill in all these gaps so that every death in a community is understood and explained. So because of that broad function, the vast majority of death investigations don't result in criminal charges. So in the county that we're actually talking about, Waukesha County, in 2010, the most recent year that we have statistics, according to their website, they conducted...
Is this in the record?
No, but it's judicially noticeable, I think, because it's online on their website.
Who asked for the toxicology report here?
The medical examiner did.
Okay.
So they conducted 1,374 death investigations in 2010. There were only 2 homicides. 80% were natural, 15% accidental, 5% suicidal. And even the majority of drug and alcohol toxicity cases don't end up being homicide cases. In 2010, there were 40 such cases. 30 were determined to be accidents, 10 were determined to be suicides. So from the perspective of the medical examiner, this was just a routine run-of-the-mill death investigation.
Well, one of the reasons that you ask who asked for the examination and does the lab know the purpose is because people's perceptions and the way people do things is colored by who asked, may be colored by who asked for it and what is the purpose, right? I mean, we've had numerous cases where people in labs made dishonest mistakes, right? In fact, in some counties, in some states, not in Wisconsin, you had hundreds of such examples and hundreds of cases that had to be redone, right?
Right.
And that's why these questions are asked. That's why I asked you, say who did this. But I want a global answer. Now you're dealing with this rare thing. I want a global answer of what the solution should be, or don't you have one?
A global answer to what? To what the test should be for
Yes.
testimonial statements?
So let's tell the circuit courts how to handle this. Let's tell public defenders how to handle it, private defenders, Court of Appeals, and this court, and let us try and reduce the number of cases that involve this question. We've had a lot, right? And they're still coming.
Right.
And you intend, or you foresee that they will continue to come, right?
If this court were to hold as we ask, that autopsy and toxicology reports in general are not testimonial, if this court were to issue that holding, you would not have many toxicology or autopsy cases going
No,
forward.
we go right to the U.S. Supreme Court, and they would say, what do you mean you got a flat rule on that? A per se rule doesn't make any sense. We don't like per se rules. They say that kind of thing, don't
Well, that's why we're not asking for a per se rule. We're asking for in general, autopsy and toxicology reports are not testimonial. There are exceptional cases.
To me, counsel.
But the problem is with a per se rule, or whatever you want to call it, a bright line rule, is that, for example, if law enforcement had, in this case or another case, requested the toxicology report or was involved in speaking with the medical examiner while she, or during the course of her conducting the autopsy, then we might fall into the testimonial category, right?
Right, yeah, I think the exceptions will not be hard for lawyers and judges to apply because the exception is essentially, is it obvious that what you're doing during the autopsy is producing evidence? So the types of factors that other courts around the country have looked to is the violence of the crime. Most of the cases where courts have found autopsy reports testimonial involved a violent shooting. Or if the police participated in some way, if they're present during the autopsy and the medical examiner is pulling fingerprints and actually producing evidence, then I think it's pretty clear. But
All right, so it'll be clear because we can look at the primary purpose of why it's being done.
That's right, yeah.
I'd like to take a step back for just a moment, make sure I understand the basis upon which you distinguish Wilcoming, Melendez-Diaz, Griep, and so on. Is the distinction that the tests in those cases provided the ultimate question, the answer to the ultimate question. So in a BAC context, it gives you the BAC number. That's an element of the offense. When you're testing for what a substance is and the result comes back and it says it's heroin, it's whatever it might be, that's an ultimate question. Whereas in this case, this provides some numbers, but that's not the ultimate question, right? The question is not did you die of 6 MAM in a certain quantity. The question is not did you die of morphine in your blood. The question is did you die of a heroin overdose? And in this case, the report doesn't tell you that. In Bullcoming, Melendez-Diaz, those reports told you the ultimate answer. Is that the basis for the distinction?
I think that's one important factor. I don't think that's the main thrust of argument, but yes, I think that's a very important factor to point out. I think that's both relevant to whether the evidence is testimonial, but also relevant to whether the medical examiner's opinion was independent. Those two separate issues. The fact that the report doesn't actually contain the ultimate question that we care about, whether Luke died of heroin, shows that her testimony was independent because she had to apply something more to the toxicology report. So I think yes, it's relevant to both. I want to talk briefly about harmlessness because I see my yellow paper is on.
Before you do that, I have a question. You were with the assertion that most autopsy and toxicology reports are not testimonial. Then you were asked about, well, what about it? Law enforcement is involved, police is involved, the state is some way involved. That's, of course, the case in probably most OWI cases, right? You have some kind of a toxicology report that's requested by the police or other alcohol-related things. So it seems to me that once you superimpose the requirement or the test that, oh, but if the state is involved, it is testimonial, that really changes your premise that most toxicology reports are not testimonial.
By involved, what I meant was actually involved in the physical autopsy. So there's a couple cases.
Okay, I want to stay on toxicology, though, not autopsy. You said most autopsy and toxicology reports. Okay, but are you standing by that?
Yes. I mean, we're asking for a general.
Are not testimonial.
Yeah, we're asking for a general rule about both, and the statement that I made was that if the police participated in one or either of those reports, and what I meant by participation is not, that they were at the scene of the crime initially. What I meant is the police were engaged in, like if the police had conducted the toxicology report itself,
what about requesting? And that's what I heard part of the inference, and I may be wrong, but the inference of the question included, what if the state had requested it? You're saying, no, they have to be there holding the needles and draining the blood?
I'm not saying they have to. I think that's an important factor. If the police were the ones who requested the toxicology report, that would also be a very important factor. But they didn't. It was the medical examiner who requested the toxicology report.
If the police requests a toxicology report, is that testimonial?
It's more likely to be testimonial. I don't know that it always would be. No.
Is the medical examiner a paid city, state, county official?
I see that my light is on, ma'am.
Yes, you may answer that one question.
Okay. Yes, the medical examiner's office is independent from law enforcement. It's appointed by the county executive, approved by the county board. It's paid by the county. It has its own independent function that's separate from law enforcement, and I think that's very significant.
Thank you very much.
Thank you.
And we all will look at your briefs again in regard to harmless error because you did talk about that.
Marcia. I'd like to address the question you had posed, Justice Gableman, when I was up here before. I don't think there's any indication in the record that the state turned over an expert report or any underlying notes or raw data or anything like that that's associated with the toxicology report. The only thing in the record is the toxicology report itself. And sure, the defense could have requested that material perhaps, but discovery violations are a separate issue from the confrontation clause violation. And if the defense would have had the raw data and records and notes, that could have provided fruit for cross-examination. So I think it only potentially compounded the constitutional error in this case. Does that answer your question?
The thrust of my question was not as a curative. It was more of a procedural. And I was curious to know the timing. If it's not in the record, it's not in the record. And I thank you for your response.
Okay. I wanted to circle back and talk about my first main point in this case, that the autopsy, or the toxicology report is testimonial. And it's testimonial under the United States Supreme Court's primary purpose test. And the court developed that test over a series of 3 cases: Davis versus Washington, Michigan versus Bryant, and Ohio versus Clark. And these cases establish that statements are non-testimonial when their primary purpose is to respond to an ongoing emergency or to enable police to respond to an ongoing emergency. But they are testimonial when there is no ongoing emergency and the primary purpose of the statement is to establish or prove past events potentially relevant to a later criminal trial. And, as the state, it formulates the primary purpose test somewhat differently, as counsel mentioned. It states that statements are testimonial if their primary purpose is to create an out-of-court substitute for trial testimony. testimony. And Ohio versus Clark, which is the most recent United States Supreme Court case on the primary purpose test, does use that language, but it also uses the language that I previously mentioned, that a statement is testimonial if its primary purpose is to establish or prove past events that are potentially relevant for a later criminal trial.
Counsel, for specific application in this case, I'm looking at Melendez-Diaz, and Justice Scalia went through in great detail the classes of testimonial statements that are covered by the Confrontation Clause, drawing on past case law. And I think pertinent to this case would be this category: statements that were made under circumstances which would lead an objective witness reasonably to believe that the statement would be available for use at a later trial. So the witness in this case has got to be somebody from the laboratory. Would you agree with me?
Yes.
Okay, so I'm going to go back to an earlier question I had. What do we have in this record to suggest that a witness from that laboratory would reasonably believe that, if you want to call it a statement, this toxicology report would be available for use at a later trial?
Well, you have to look at all the circumstances under which the document is created, not just one position, but you have to look at the circumstances under which the encounter occurs, the statements and actions of the it's not the interrogator, but the office requesting the report. And in this case, the office requesting the report is a government agency, the medical examiner, that's engaged in a death investigation that's involving a suspicious death that suggests that the cause of death was a homicide. It's a Len-bias homicide, but a homicide nonetheless. For Confrontation Clause purposes, this is no different than a violent death like a gunshot wound. The circumstances of the death in this case would lead a reasonable person to suspect that a homicide had been committed. And I think under these circumstances, where you have a suspicious death where the circumstances suggest a homicide, you have the police investigating the case as a homicide, the medical examiner's office is aware that the police are investigating this as a homicide.
But what about the laboratory? What did the laboratory know?
The laboratory would have known that this could potentially be used for a later criminal trial. They were asked to test for contraband substances in relation to a death investigation. They were told that Mr. Luck was 27 years old at the time of his death, found unresponsive at his home. And I think it's also significant that the medical examiner sent not just blood and urine samples, but tissue samples from the injection site to be tested. I think the toxicologist would certainly have known, or should have known, that his report was something that could be used in a potential criminal trial. I also wanted to circle back.
Did they have a contract with St. Louis University Lab, Waukesha? They seem to have used it a lot since 2009. Okay, not in the record, maybe.
Can I answer that question?
You can answer that one question, yes.
I'm not aware if they had a contract, but it's my understanding from the record that they regularly use St. Louis University Laboratory.
Thank you very much.
Thank you.
By definition, when the medical examiner asks for this, it means you don't know what the cause of death is. That is, you can't get somebody to verify that it's not a problem, not a crime.
I think it's,
Yeah, she's just making a statement. I didn't notice a question there at all.
Well, question, right?
Yeah.
Isn't that the point of a medical examiner asking for a report because he can't get, or she can't get, a doctor to state that it was natural causes? Therefore, it's under suspicion.
It's for purposes of investigating a possible crime.
Exactly.
Thank you very much. Thank you all for your presentations. They were very good, and your briefs were excellent as well. So it's a sticky question and not an easy one to answer, and it won't be easy for us to sort through any more than it has been for you all. So we will now take a break so that another group can come in, and we'll be back again when our trustee marshal calls us. We are adjourned.
Mr. Wisconsin, I'm Kevin Zizicki, otherwise known as Beth Myers' husband. You know, Beth Representative Myers, over there in the flat. I live in St. Paul, so I always tell people how many people can watch their spouses on TV. So I want to thank you for what you do, because a lot of times when she's on the floor,
Justice on Wheels program. The Wisconsin Supreme Court, which routinely holds court, as you know, at the Supreme Court chambers in Madison, Wisconsin, is today assembled here at the courthouse in Washburn as part of the Justice on Wheels outreach program. Bayfield County is the 27th county outside of Dane County where the Supreme Court has held oral arguments since the program's inception in 1993. Justice on Wheels gives people outside of the Madison area, including students, teachers, and the general public, an opportunity to observe the court in action. During the proceeding you are about to witness, lawyers will present oral arguments advocating their client's position. Justices will have an opportunity to respond or ask questions directly of the lawyers during the presentations, which have precise time limitations. As you know, both in the state and federal law, there are three branches of the government: the executive branch, the legislative branch, and of course, the judicial branch. They each have distinct purposes and functions. In Wisconsin, there are three levels or branches of the court: the circuit courts, and there's at least one circuit court in each county. In Ashland County, our judge is Judge Eaton, and in Bayfield County, it's Judge John P. Anderson, who, as I believe a lot of you know, was very instrumental in getting the Justice on Wheels program here today. And Judge Anderson, we thank you for that. Okay. Circuit courts are courts of original jurisdiction, i.e., they're the first to hear a case. Decisions from the circuit court may be appealed to the Court of Appeals as a matter of right in most cases. In Wisconsin, we have 4 different courts of appeals headquartered in different parts of the state. Ashland and Bayfield County are in the 4th district, which is headquartered in Wausau. What's that? Third district? Sorry about that, but it is headquartered in Wausau. Okay, good. Thank you, Justice. Judge. Once the Court of Appeals hears a case, a party may petition the Supreme Court to hear a case decided by the Court of Appeals. Appeals to the Supreme Court are not as a matter of right. The Supreme Court, based upon petitions for review, decides which cases they will hear. The case you are about to hear is before the court because the Supreme Court has decided there are important legal issues and legal principles for the court to consider. The case presently before the court is a civil action as opposed to a criminal case. The 2 other cases that the court is hearing today are both criminal cases. A summary or synopsis put out by the Supreme Court paraphrases and outlines the case which will be heard this morning. And I'm going to impart a quote from that. The issue presented in the case this morning arises from a dispute over liability for a workplace accident. Examines the role of caveat emptor, or buyer beware, and an exception to the rule as expressed in the Restatement Second of Torts, Section 352 and 353. In terms of factual background of the case, Russell Brenner was severely injured while he was working for Hunsinger Construction. He fell through a large hole or pit in the floor of a building owned by Milwaukee World Festival while moving a large plywood panel that covered the hole. Brenner and his wife filed suit alleging negligence and safe place statute claims against the following parties: the owner of the building, Milwaukee World Festival, a former owner of the building, Garland Joint Venture, and the former long-term tenant of the building, Charter Manufacturing. Before the owner acquired the property, or the current owner acquired the property, Charter Manufacturing was a long-term tenant of the building under a lease with Garland Brothers. Charter had used the pit for its furnaces used to heat metal as part of a wire manufacturing process. An agent of GBI assumed responsibility for negotiating the termination of Charter's lease. Before surrendering the premises, Charter was asked to fill in the pit immediately before the holes in the floor where the heat treat furnaces had been located. Charter, the long-term lessee, refused to do so. In November of 2009, Charter was permitted to surrender the property without filling the pits, so long as the pit was left in a clean and safe condition. In late December 2009, GBI did a final walkthrough of the property with its experts and Charter's representatives. GBI did not raise any more concern about the pits at that point in time. After Charter vacated the building, Garland Brothers sold the building to the current owners in its as-is, where-is condition with all faults. Those are legal terms of art that you see a lot in contract law, particularly in commercial real estate contracts. So those were incorporated in the purchase agreement. Prior to the purchase and before Brenner was injured, the current owner had performed numerous inspections and walkthroughs of the premises. Garland Brother and Charter filed motions for summary judgment on the grounds that the court was not liable for that they could not be liable for Brenner's injuries due to their relinquishment of the premises well before he was injured. The Bremers and NFF opposed those motions. The trial court granted the motions for summary judgment. As relevant here too, the trial court found that the restatement of torts second, section 352, acted to bar the Brenner's negligence claim against Charter. Following the motions for summary judgment, the trial court dismissed the Brenner's negligence claim against Charter and Garland Brothers on the grounds that it was barred by the doctrine, as I mentioned before, caveat emptor, buyer beware. The trial court reasoned that because Charter had already relinquished possession of the premises before the current owner purchased the property and before Brenner was injured, Section 352 applied to shift liability from Charter to the buyer. The current owner appealed Charter's dismissal from the lawsuit. They lost the case at the Court of Appeals and now ask the Supreme Court to review several issues, including the following. Should Wisconsin adopt the restatement third of torts, section 51, which supersedes the restatement second of torts, section 352 and 353? Does the restatement of second torts, section 352, relieve former possessors of land like Charter from liability for hazards created at their discretion? During the oral arguments, you will likely hear references to the second and third restatement of torts. Tort law is that body of legal rights, obligations, and remedies that are applied by courts in civil proceedings to provide relief to persons who have suffered harm from wrongful acts of others. In American jurisprudence, the restatements of the law is a set of treatises on legal subjects, such as torts, that seek to inform judges and lawyers about general principles of common law. As one authority references the restatement of torts, and I quote, individual restatement volumes are essentially compilations of case law, which are common law judge-made doctrines that develop over time because of the principles of stare decisis. Although restatement of the law are not binding authority in and of themselves, they are highly persuasive because they are formulated over several years with extensive input from law professors, practicing attorneys, and judges. They are meant to reflect the consensus of the American legal community as to what the law is, and in some cases, what it should become. And you will hear that, I believe, during arguments here today. The legal issue and dispute concerning the summary judgment motion filed in this case involves whether Charter Manufacturing, the tenant, owed any duty of care to Bremer, the injured worker, or the plaintiff. Milwaukee World Festival, the owner of the building, argues that Charter Manufacturing has a duty and liability pertaining to this accident. In part, the owner is relying upon Section 51 of the third restatement of torts. There is no existing Wisconsin case law which has adopted or applied this principle of law. Milwaukee World Festival, the owner, argues that current Wisconsin law is out of step with modern notions of accountability for negligence that focus on notice and causation rather than possession and control. Brenner, on behalf of long-term tenants, counters as follows, that the court should not adopt the third restatement of torts because it is inapplicable to these facts, particularly because MWF contracted that the risk of loss be allocated to it, in other words, when they purchased the property. Moreover, such a drastic change in the law should be left to the legislature because of the societal impact its adoption would create. Brenner argues that it is the role of the legislature to identify and enact public policy initiatives, not the court, going back to that division of the three different functions of government, as I mentioned earlier. The trial court concluded it lacked jurisdiction, or it lacked authority to address the issue as to the applicability and adoption of the third restatement of torts. Apparently, the Court of Appeals did not address the issue. Accordingly, it will be interesting to see how this issue is handled during oral arguments, both by the attorneys and by the justices of the Supreme Court. Another issue which will likely be addressed during oral arguments is a provision from the second restatement of torts, section 352, which provides in part, and I quote, that a vendor of land is not subject to liability for physical harm caused to his vendee or others while upon the land after the vendee has taken possession of any dangerous condition which existed at the time that the vendee took possession. Vendor and vendee are legal terms. A vendor is a seller or owner of the property. The vendee is the purchaser of property. Charter was a long-term tenant and was not the owner or seller of the property. There is no Wisconsin case law addressing the issue of whether a possessor of land, i.e. a tenant, is entitled to the protections of section 352. Both the trial court and the Court of Appeals relied upon out-of-state decisions, one from Alaska and one from Indiana, to conclude that a possessor of land was akin to a vendor and therefore entitled to the protections of section 352 of the second restatement of torts. The fact that there is no Wisconsin case law on this issue may be one reason the Supreme Court has decided to hear this case. I hope these comments have been helpful to you in terms of what you will be witnessing here this morning. Thank you.
Some of you recognize me as the person who was yelling at me. If you're going to speak, I'm Gina, the marshal. I just want to tell you a few rules. Please, no talking, no electronic speed limits during the oral argument, no eating or drinking. Those are kind of the highlight of the rules. Good luck, and I'll see you shortly. All rise. The court is reconvened. Your silence is commanded.
Please be seated.
Before I call our second case, I will let the lawyers know, and those of you who are out there know, Justice Rebecca Bradley is not going to participate in this case, so she is not with us here for this argument. Sometimes a justice was either a judge on a case before. I don't know what her reason is, but she was both on the Court of Appeals and on the Circuit Court, so it's possible she had some involvement, or perhaps she was a lawyer that was involved in the case. I don't know, but she's not going to be participating in the case. She made that decision. So the case is our second case for the day, Brenner versus National Casualty. Are you ready to begin?
I am.
Very good. Now, you ready? Okay. Please begin.
I would like to reserve 7 minutes for rebuttal.
Say it again.
7. 5. 5.
5, and you have it. How's that?
Sold.
That's right.
Good morning, Justices, Ms. Tyndall. My name is Pamela Schmidt. I'm an attorney with the law firm in Milwaukee of Scopolitis, Garvin, Light, Hansen, and Feary. It is my privilege today to represent National Casualty Company and its insured Milwaukee World Festival, also known as the Summerfest people. The case that brings us here today is undoubtedly a tragic case. It involves severe injuries to Mr. Brenner. The nature of those injuries are not, at least at the moment, in dispute before this case. Everybody agrees that he was severely injured when he fell through a hole on premises owned by Milwaukee World Festival. He was employed by Hunzinger Construction at the time that occurred, and he fell through a hole that had been created at the direction of Charter Manufacturing Company, which had been a long-term tenant of Garland Brothers joint venture. So that's the brief overview of the salient facts for the case today. The case is was sought to be reviewed by the court by my clients for 3 reasons. The first would be seeking application of Section 51 of the Restatement Third of Torts as the more recent and accurate articulation of the law in the country. Second, to limit the application of Section 352 of the Restatement Second of Torts, which was the restatement applied by both the Circuit Court, as it felt that it did not have the authority to reach out and extend new law, and which was not applied by the Court of Appeals with no real explanation given as to why it did not address the Section 51 argument, but instead extended Section 352. If the court determines that Section 352 is in fact applicable to this case, then Milwaukee World Festival also argues that Section 353 provides exceptions to that application, which are important and should be applied in this case so that the immunity granted by Section 352 is not extended to Charter, and Charter is held liable, or potentially held liable, for the creation of the holes.
If we were to adopt, oops.
Go ahead.
Okay, it'll be short. If we were to adopt Section 51 and accept your argument, could a property still be sold as is, where is, with all faults? Would that mean anything?
Yes, I think it could, and I think it does. And in fact, in this case, I think it does as well. I think there is some confusion of the issues in this case. As the case is presented currently, this is all about Mr. Brenner and his wife's ability to sue Charter and to potentially hold Charter responsible for its negligence. It has nothing to do at this moment with the negligence of Milwaukee World Festival. Milwaukee World Festival and other parties may contract, and the jurisprudence of Wisconsin favors allocation of risk via contract, and nothing about the adoption of Chapter 51 would alter that.
Okay, Counselor, this must have something to do with Milwaukee World Fairs, doesn't it? Why are you here?
Well, it does to the extent that Milwaukee World Festival is seeking a proper allocation of all potential liability.
Right, because you have a contribution claim.
I believe that there is no cross-claim. It's just an issue of who goes on to the verdict form, so that the jury would make a finding of Charter's negligence, Milwaukee World Festival's negligence, and any other.
Why are you making this argument if the Brenners seem to be comfortable with the resolution?
The procedural history of this case is very interesting. Milwaukee World Festival did oppose the summary judgment motion in the circuit court because it is interested in having all potentially responsible parties on the verdict form.
Yes, but not just as an intellectual matter, right?
No.
You want to pay less.
Correct.
Okay.
Correct. I mean, the end result of having more parties on the verdict form is that the jury, ultimately, if the case is tried, will allocate potential response, or will make the determination of the allocation of responsibility. If the jury is presented with the negligence of Charter, it is our belief that the jury will conclude that Charter is more responsible than Milwaukee World Festival. But for today's purposes, that allocation and determining is Milwaukee World Festival more negligent or is it in fact negligent at all is not really before the court. And the as is, where is clause, that allocated risk between Milwaukee World Festival, the purchaser of the property, and Garland Brothers joint venture. So as between those two entities, Milwaukee World Festival has accepted that allocation of risk contractually.
All right, I want to get to that a little bit later perhaps, but right now, could you tell me if there actually is a conflict between restatement third towards section 51 and restatement second towards section 352? And in particular, the reason I ask is because section 352 refers to a vendor of land, so we're talking about a past tense land possessor. Section 51 talks about a land possessor, which seems to indicate a present tense land possessor. Is there a conflict between those two?
Well, Section 51 also talks about creation. So I think that Section 51 talks about the possessor at the time of creation.
Is there anything in the case law that suggests that this relates, that Section 51 is applicable to prior land possessors, not present tense land possessors?
The case law applying Section 51 is scant. It was adopted 2010, 2012, so there hasn't been a whole lot of cases working their way up from the circuit court up, so there isn't.
Would we be the first court to hold that Section 51 applies to past tense land possessors?
To my knowledge, Your Honor, you would be. There may be a case out there that I didn't find in my research, but I did not find it. Had I found it, I certainly would have cited it in my briefs. So I believe that that is, in fact, the case. But Section 51 is an outgrowth of the development of law over time, including the development of law by this court in Wisconsin, which has found on numerous occasions that everybody owes a duty to everybody else. And I think that but for the application of Section 352, everyone would agree the charter would be a potentially negligent party because it oversaw and the creation of these holes. It knew that the holes were there. It knew that the holes were covered. It turned over the premises that it had leased for many years with the newly created holes that were created at its direction, that were covered at its direction, to somebody else and made no disclosure of the existence of the holes.
Well, in the somebody else is important here, right? This was a relationship between a landlord and a tenant.
Between Charter and Garland Brothers, yes, it was.
Correct.
And there were.
And that relationship was governed by a written lease?
It was.
All right. And the relinquishment of possession in this case was governed by that lease?
It was as well. And there were some relinquishment negotiations that sort of fit in the gaps in the lease.
Okay. And so would you characterize that as a supplemental or an amendment to the lease? There were some contractual terms to which they came.
Correct. There were contractual terms, and then as is something that keeps lawyers employed, there was some disagreement about exactly what the extent of those contractual obligations were. For example, Garland Brothers joint venture requested that Charter fill in those pits. Of course, had Charter complied with that and filled in the pits, there would have been no pit for Mr. Brenner to fall into. Charter countered and said, no, that exceeds the scope of the lease agreement. We don't need to incur that expense, so we're not going to fill in that pit. To that, Garland Brothers joint venture said, well, good enough, so long as you leave it in a clean and safe condition.
Right. Okay, so now, in setting the Brenners aside for just a moment, and let's look at Charter GBJV and Milwaukee World Festival. Why are we not considering this in terms of contract allocation of risk rather than torts?
I would love to be able to answer that question, but I don't think I can do it without dragging the Brenners back into it, because the answer to that question is, while there may be allocation between charter and GBJV, and there may be contract allocation between GBJV and Milwaukee World Festival, Mr. Brenner, the injured party, is a stranger to any of those contracts, and none of those contracts address the liability of those entities to Mr. Brenner. So
That's where we are now.
Correct. Mr. Brenner was the one who brought the action claiming to be injured. At that point, I think the question becomes who is potentially liable, who is responsible for the injury that Mr. Brenner sustained. That's the nature of tort law.
And who has the deepest pocket here?
I would argue that that is not a proper consideration.
I understand that, but it's an issue, otherwise you wouldn't be fighting. So who's got the deepest pocket?
Or who has equally deep pockets.
Oh, equally, so Brenner doesn't care? It's only you guys that are on the other side of the V that care?
Mr. Brenner certainly cares about being justly compensated, but I don't think it matters to him where the money comes from, so long as he is adequately compensated for his injury. And that's appropriate.
He's not at the table today.
Mr. Brenner's, because of the procedural status, Mr. Brenner's counsel is here today standing in the shoes of charter because Mr. Brenner executed a parent release.
Okay, and when he does that, he accepts the liability of charter, correct? If there's any liability.
Correct.
So it's in his best interest that you lose, because otherwise he's got to accept charter's liability and negligence for what happened.
Exactly. Mr. Brenner would just as soon extinguish any liability of charter because under the agreement that he struck, his contract that he has now stricken with one of the parties post-accident.
Is that the Peringer release?
That's the Peringer release. He now accepts whatever responsibility charter would be held liable for should charter be on a verdict form going to a jury.
All right, so thank you. And I think now I've cleared my throat enough to ask the questions I really want to get to. Let's look at the policy implications if we were to go along with you, and we're the first in the nation to adopt this Section 51 as applicable to prior land possessors. Wouldn't that put that prior land possessor in the position of an insurer from that point forward? They no longer have possession of the property, so they cannot alter it. They no longer have an ability to control who comes onto the property. They simply have potential liability sitting there from that point to the end of time.
I understand that concern. I think that it is more limited than that, however, because Section 51 applies to the creation of hazards. So that former possessor will not be liable for anything that he, she, it did not create under Section 51 or direct to be created. This is akin to, and it's the ounce of prevention is worth a pound of cure, is that this individual or this entity in this particular case and in the rule that I'm urging that the court adopt is that if you create a hazard, you are responsible for that hazard. It's really no different than it is when we talk about chattels and a product liability. Once you put a car or a can of paint or anything else into the stream of commerce, your liability follows because of the defect in that car or that can of paint if it later on causes damage to somebody, even if you no longer have control over that can of paint or that car.
Right.
It's the same thing with property.
Yeah, and you, in a product manufacturer, can obtain product liability insurance to cover something like that. If we adopt this, aren't we almost by a necessary inference creating a new insurance market?
Perhaps. I haven't analyzed every form of insurance available, but I don't think it's a wholly new market because there are, in fact, claims that go back to former possessors. There are CERCLA claims, there are all sorts of environmental claims that people look back to former possessors because they've dumped lead or they've dumped asbestos or something else.
And those are statutory creations of liability.
Correct, they are. But I'm just talking about the insurance market. If, in response to your question, there are insurance policies that do address former ownership. I don't think it's that great of a stretch that if we have an insurance market that addresses liability that arises from asbestos or lead paint or all sorts of other environmental contaminations, that it's that big of a stretch to say that an insurance market will cover other risks that were created. Well, it's another type of hazard, it's just not lead paint or asbestos. So I think that market is, if it doesn't currently exist, and I am not an insurance market expert, if it does not currently exist, I don't think it takes very much for it to develop.
How long between the time that Charter left the building and the injury?
Charter left the building at the end of 2009. The injury was at the end of 2011.
Okay.
Milwaukee World Festival picked up the building in May of 2011. It did not have the property during that entire time.
All right, but unlike the paint, and really unlike the car, and unlike other products that are put on the market, in the building, you can inspect the building, can find out if there are openings in the floor that can cause damage, and you can repair them. So how long would Charter be liable? I mean, you may have 20 years go by, nobody falls, everybody steps on the covering, and everything is just hunky-dory, and Charter is still liable, even though you've got a lot of owners and possessors that can do repairs, right, and should do repairs.
Well, I will acknowledge that this is a somewhat of a unique presentation, which is why it's before this court, but I don't think that that is...
Well, you would ask for the same rule even if it was 2 days.
Correct. I think that the touchstone for liability here is not the passage of time or the title of the person. It's not tied to possession, it's tied to creation. And in this case, the reason why I think that's important is, in this case, Charter knew it had created those holes.
Okay, but then you would say Charter is always going to be liable because it created the danger.
Correct. It created, and it could have, before it surrendered the property, it could have fixed the danger.
Right. But the subsequent possessors or owners could also have fixed it up.
Correct. And they could also be found liable. That's an allocation of liability. That's where right. Everybody goes on the verdict form.
And you want everybody on the verdict.
Correct. It's an allocation. I'm not looking, this case, we're not here arguing that Charter is solely responsible and Milwaukee World Festival is not. It is seeking a proper allocation, which should be determined by a jury because it's a question of fact.
And what about selling it as is?
Well, selling it as is may, with a contract, and there are cases that discuss exceptions to as is, where is, in terms of whether it's a latent defect or not. But setting that aside for the moment, if it were sold as is, where is, that would allocate the responsibility to the new possessor.
But
so in this case, right, in this case, Garland Brothers is no longer here. We're not seeking review of the determination that Garland Brothers be excused because it allocated its liability, arguably with the as is, where is clause to Milwaukee World Festival. However, Charter did not allocate that responsibility contractually or otherwise to Milwaukee World Festival.
Did Milwaukee World Festival sue Charter?
It did not. The Brenners sued Charter.
Okay, so did Milwaukee World Festival sue any of the other defendants?
It did not.
Thank you.
Counselor, I'm concerned about the potential of upsetting settled expectations. So when I look at the sale from GBJV to Milwaukee World Festivals, I'm assuming that contractual language, as is, where is, and I think it goes on to say with all defects.
With all faults, yes.
All faults. All right. That informed Milwaukee World Festivals on how much it ought to pay, right? If you're accepting a property as is, where is, with all faults, you know there might be something wrong, and you factor that into the purchase price. Aren't you stealing a march on GVJV by now saying, let's allocate some of that risk back to Charter because they created this, and now I get a discount because of potential liabilities and problems with the property that I don't have to pay for because I get Charter to pay for part of it.
Charter, I don't think, has any expectation. Charter could not have known what its...
I'm talking about your expectation.
With Milwaukee World Festival's expectation?
Yes. So Milwaukee World Festival pays a certain amount for the property. I don't know what it is. But I'm relatively sure the amount would be different if the as is, where is, with all faults clause was not there.
That's true, but again, that's an allocation between GBJV, Garland Brothers Joint Venture, and Milwaukee World Festival.
All right.
We
are talking about the printers, yes. However, given the current state of the law, and as you have explained in your briefs, the current state of the law in Wisconsin is at least analogous to Section 352, the Restatement Second of Torts, which is that prior vendors are not liable to entrance to the property except for those exceptions in Section 353. So when Milwaukee World Festival purchases the property, it does it against that backdrop and factors that into its purchase price, right? Because you don't win this case unless we adopt Section 51 as applicable to prior landowners.
No, I don't agree with you with that, Your Honor, because I think Section 353 also applies to this case, and I think the exceptions apply. So either way, whether the court adopts Section 51, which I think is the more modern and the cleaner rule and makes everything easier going forward, or whether the court leaves 352 in place, then I think the court needs to make a factual, well, it needs to look at 353, which involves a number of factual determinations, some of which were...
I want you to finish that thought. We need to make a factual determination.
Well, as you say, the issue with 353 is the Circuit Court and the Court of Appeals weighed competing inferences, and they reached opposite conclusions. So it struck me that where you can have two reasonable courts reach differing inferences, that is something best left for a jury, such that summary judgment was inappropriately entered in this case. Moreover, the Court of Appeals actually made an error in one of its findings of fact. I have a note somewhere about which paragraph it is, but it concluded that Milwaukee World Festival had been storing equipment in the location where the fall happened. And in the respondent's appendix, actually, at page 107, Mr. Snow, who's the director of facilities at Milwaukee World Festival, testified that they explicitly did not store equipment in that location. So there are some factual errors that were made and some inferences that were made by the Court of Appeals that differ from the Circuit Court. So it's a long way of circling back around to, I think Milwaukee World Festival wins 2 out of 3 times. Either you adopt Section 51 or Section 353 is found to apply that there are issues of fact and it should be remanded to the trial court so that the jury can make those determinations about did Milwaukee World Festival have appropriate notice, should it have known that these holes were there based upon the indirect evidence that was before it. There's no testimony that Milwaukee World Festival had actual notice of the holes over the pit.
Counsel, on page 19 of your opposing counsel's brief, it quotes from Godoy, 2009 case, saying, quote, adopting the restatement third approach to property owner liability would be a sea change in Wisconsin law. And generally, not always, generally courts develop the law incrementally. And the assertion that something is a sea change causes us to hold on to our chairs and off we go. You know, that's not normally the way courts act. Respond to this assertion of sea change that this court stated adopting the restatement third's approach to property owner liability would be a sea change in Godoy.
With all due respect to the court, which has far more experience than I do in this area, I think that that's a misstatement. I don't see it as a sea change, and I'm aware that Godoy said that. I think it's incremental. It goes way back, back in, I believe it was 1961, there was a case that we did not cite, but talked about caveat emptor being an obnoxious cliche. So that's Pines versus Persian. And there was there are other cases that talk about we've been moving away from caveat emptor in other contexts within real estate. We now have to make disclosures. If it were truly buyer beware, it would be, hey, take your luck. We take a look, and everybody's then playing hide and go seek and seeing if they can find what the latent defect is, or where do I need to inspect and where don't I need to inspect. It would be more efficient not to engage in that procedure. I see I have my red card up.
Another way of asking that question is what cases would we have to overrule to reach your result?
To overrule, I believe there are just two cases.
Okay.
And I believe those are Bagnowski versus Preway and the McCarty case. I think it's McCarty versus Covelli. And frankly, I think those are distinguishable by facts, so I don't know that a bright line overrule would be necessary, except that those two cases do find that Section 352 applies. Those are the only two.
Very good. Thank you so much.
Thank you.
Sorry, excuse me. I'm Susan Tyndall of Habish, Habish & Richier. I represent the Brenners. And I guess I should start with the sea change. It is a sea change in the law because Wisconsin has long held that a seller or vendor of property or other transferor of property is not liable for injuries or events that occur at the property after possession has changed hands. And there are a number of reasons for this. Excuse me. In part because the vendor no longer has control of the property. But another reason is they no longer have control of who comes into the property. And the Preston case from California, which we relied on, I think really makes a lot of excellent points and explains why adoption of Section 51 of the restatement would be the wrong move here, as I think elsewhere. When you're in possession of your property, your home, you might build something that suits your purposes. So in the Preston case, the family that lived in the home initially, I believe their name was the Kubitscheks, they built a pond or a pool with a fountain in it. And they kept the house for a while, and then they sold it to someone else who then leased it to another person. And then the lessor invited friends over that had little kids. Nobody was watching the little kids. And one of the little kids fell into the pond and was gravely injured. If you build a pond for yourself, if you're an empty nester, that pond is perfectly fine. There's no breach. There's no problem with that. If you invite friends with little kids over, you're aware of the pond, and you can take steps to control the little kids near the pond. But if you build a pond that's acceptable for you and your uses when you're there, and then you sell the property later to someone else who has a different family, different guests, and different needs, you're unable to control what happens with the pond, how they supervise their children. So if you create the pond that's perfectly safe for your purposes, you can be liable 20 years later because someone else invites friends over with little children and the children aren't properly supervised. Not only do you become liable for something that wasn't a breach when you are in control, there's no insurance for that. And sad to say, I've spent a lot of my career reading insurance policies. and so when there are reasons, when we talk about former possessors who are sued for pollution or whatnot, in those cases, the old policies covered for an occurrence during the policy period.
Two kinds of policies. Explain that. One is the occurrence, and the other is
claims made. But even
exactly.
but there's even a change in the occurrence policies. In the occurrence policies back in the old days, they used to trigger coverage on the happening of the occurrence during the policy period. Then when they started to get these long-term claims like pollution claims, when the occurrence occurred in the 40s, and now all of a sudden it was the 70s and the insurers were getting these long-term claims, they changed the policies and now they're triggered by by bodily injury or property damage occurring during the policy period. So that's the reason why in some of those cases involving those long-term torts, there is an argument for coverage. Most policies, your homeowner's policy covers your insured premises, which means the house you live in, and it will also cover vacant land. But they do not cover homes that you previously lived in. So this would be uninsured. And the Preston case discusses that and cites some cases for that proposition. In addition, if you have a general liability policy, so if you're of a corporate interest and you've moved to a new premises, those policies have property damage exclusions, which preclude coverage for premises that you've sold or abandoned and no longer occupy. So in both the commercial and the personal lines of insurance, there's no coverage for this type of risk. So that means that if we're empty nesters as of this fall, we are thinking about downsizing at some point, we could be sued and face an uninsured loss for something in our home, which is an old farmhouse, which has plenty of issues anyway, 20 years down the road, that would be uninsured.
Oh, well, the insurance companies will come in and they'll write a policy. There's no problem about that. If there's liability and there's money, some insurance company will write that, right?
It's possible that they would, but remember, insurance companies don't cover known risks. So they're not going to start covering today for liability that may have occurred 20 years ago when I remodeled something in my house.
No, but we have to look forward.
If you do look forward, they might start covering, there might be a market that comes up for that, but at this point, it puts all these DIYers, do-it-yourselfers, at risk for an uninsured claim for everything that they may have done in the past. And in this particular case, it wasn't even a DIYer. The charter hired a contractor to build these platforms or covers.
Yeah, Counselor, before you go into that part, because I know that's significant to you in your brief, charter was dismissed on summary judgment.
Correct.
So what is the evidence, if we look at section 353, restatement second towards 1A, what is the evidence that the vendee did not know or have reason to know of this condition?
Well, I don't think there's any evidence that they did not have reason to know.
I'm sorry, yeah, what's the evidence that they knew or had reason to know? Right, that's the key.
That's the key. And first of all, the property is sold as is, whereas with all faults. And in their contract, they agreed that the closing is conclusive evidence that they inspected and were satisfied with the condition of the property.
So does the contract preclude contesting that question of knowledge or reason to know?
I don't know that it necessarily does. I think that the rule with respect to as-is contracts is that it doesn't preclude any further liability, but it's an important factor in assessing what they know and what they should have known.
Yeah, so if we're talking about the tort context, put the contract to aside for a moment, didn't the circuit court need to conclude that the GBJV about this.
So the circuit court did conclude that GBJV had reason to know, which is what section 353 requires. And so Charter is a triple net tenant, which means it has possession and control for 20 years.
Yeah.
But if you look in the record, GBJV had an annual inspection with a structural engineer every summer. So every year for 20 years it comes through the building, including 2009. By the time it inspects in 2009, it knows that Charter has said, we plan to vacate. And so the inspection was imbued with this particular knowledge. In addition to that, Charter, GBJV and its agent, GBI, Garland Brothers, their property manager, secured a report from ManEdge, and one from U.S. Fire, and one from Langer Roofing. So they got 3 additional reports from experts going through the property very carefully to assess the condition. They
and we can know this beyond peradventure that GBJV had reason to know. There's no possibility of contesting this at trial.
I don't think there's any reason you can contest this at trial. So the ManEdge report, the first item on its list was pits in the building. So and then there was a correspondence between the attorneys for GBJV and Charter about filling the pits. Charter says, that was here when we got here. We didn't contract for that. We're not going to fill it. And GBJV says that's fine. Leave it in a clean and safe condition. On the 31st of December 2009, GBJV does an extensive walkthrough with Charter. They go through the whole building. And so if you're coming in every year to do this inspection with a structural engineer, you would see these big machines coming up through the floor. And there's a graded floor for venting, and then there's holes in the floor, and you can see that these machines come right up through that floor. And in fact, MWF's general counsel, Nicotera, testified he remembered seeing, and both courts, the Court of Appeals and the Circuit Court, remarked on the fact Nicotera remembered seeing those machines coming up through the hole that in 2009 before Charter had vacated. So you already know that these machines come up through the hole, through the floor, and then when you inspect, the area where the machines is covered with these plywood covers. That should suggest to GBJV, which insisted on removal of the equipment as part of the lease terms, that those covers cover that hole.
Did the same person inspect the premises after the equipment was removed as inspected it prior to the equipment being removed?
Yeah, the same people from the property manager went through on December 31, and the same expert man from ManEdge went through on that date. So there was an extensive walkthrough on the 31st of December, and following that, there was correspondence from GBJV saying, we want you to do this and this and this and this. And the pits, nothing about these pits or their covers was mentioned, but they said, you've got to clean these greasy walls, you've got to fix this and that. I mean, if they were so concerned that they were complaining about greasy walls, one would think that they would be sufficiently aware of these covers to say they had a problem with them. And in fact, that was their testimony. If we had a problem with them, we would, or our experts had a problem with them, we would have let Charter know. They did let Charter know about other problems, but there was nothing further about that pits or the covers.
Go ahead.
MWFs came through before purchase. They were right next door. So they came through before they purchased the property. They're very interested in having this because it's right next door to where their offices are. They saw those machines in place, and Nicotera testified that because they were next door, they saw them going out of the building. So there's more reason to know. Then afterwards, on the day of closing, there was an MWF employee, I think it was Goss, who had a key pre-purchase and was able to go through whenever, wherever for planning purposes. Then there was an inspection period of at least 4 months after the offer to purchase was made, where numerous people were in and out. During that time, part of the roof caved in, and there was apparently different sections on a different section of the building. Part of the roof caved in. People were in and out of the building at that time because of that. There were inspections and whatnot going on. Environmental inspections were going on. Reports about the environmental inspections came back discussing the covered pits. And if there's a pit with a cover, what does the cover cover? A hole. So there were reports in January about the covered pits, and then 2 days after closing, another report came from another environmental expert discussing the covered pits and even the location of the pit. So clearly MJF had reason to know that there were covered pits and reason to inspect.
Do you think that, Ms. Tyndall, you want us to affirm the Court of Appeals? Right?
Correct.
That can be done on several levels. One, it's a very simple summary judgment, and that there's no disputed facts, and everybody goes home. A second way of doing it, which is, I assume, why we took the case, is to discuss which restatement this court favors, right?
Correct.
And as I understand the Court of Appeals decision, they say that no matter which way we do it, we come out in your they come out in your favor. One, that there was enough time here and enough evidence that the new owner could, even the old owner, could discover this and had reason to know about this defect, had time to fix it. So either you take whatever restatement you take, you win. Do you agree with that? Do you think that this court should do it on a very simple summary judgment, which is the first few paragraphs, or should we go in and discuss it in terms of the new restatement and the old one?
Well, a number of courts have discussed the new restatement and the old one. The Preston case predates the new restatement, but there actually was a very recent January of 2016 Texas case, which normally I would have sent the citation to you, but I just shepherdized Monday night. Sorry, and they refer to 51, but they don't adopt it or discuss it in detail. They say that they had mentioned it in a prior case, but they reject application of section, not section 51 per se, but more the rule that creation of a defect should lead to liability long term, as opposed to just if you're selling the property, you've sold it and you're done, which is the rule contained in Restatement 352. And it's Occidental Chemical Company versus Jenkins, 478 Southwest 2nd 640 from January 2016. It's the Supreme Court of Texas. And they decline to change their rule and say that the creator of a dangerous condition should be liable after the property changes hands. And one of the reasons they so conclude is that there's no breach until the other people are exposed to the property, at which point the party who's created the condition has no control. In addition, though, they say, and what I didn't want you to take it from me, they say that that rule is contrary to the weight of authority. And so should you desire to address Rule 51, I believe the court should reject it for the same reasons as the Preston court rejected the same arguments, and that the Occidental case as well. It is against the weight of authority, and therefore not really the modern interpretation of the law, but rather it was the drafter's suggestion regarding how the law should be. But the courts aren't accepting it, and I think the fact that it would have these vast societal impacts because there's no insurance would be a basis to reject it, as well as the fact that in many circumstances something you create for yourself that isn't a breach could somehow become a breach later when others become present at the property and you are unable to supervise who uses it, how they use it, how they supervise children around it. So there's unanticipated liability and a great change in liability for former vendors of property, both personal and commercial.
Is there anything about the Court of Appeals decision you would change?
No, I think the Court of Appeals decision was correct. It correctly analyzed the law, and it ran through the facts that supported MWF's knowledge or reason to know of the condition in a very straightforward and easy to understand manner.
Counsel, I'd like to talk to you both, but obviously separately, about kind of the practical consequences of this case. You have an owner of property who leases on a long-term basis the property to charter. We now are hearing argument about charter being inappropriately dismissed essentially from the case and the wish to pull charter back into the litigation. Charter was a lessee of the property, and yes, they had this machinery and structures and whatnot, but when this property was being sold, the property was being sold to Milwaukee World Festivals because Milwaukee World Festivals thought they wanted to tear it down, use it as a parking lot, not really even use the structure. What, if any, impact should that have on whether a lessee of the property should be responsible for the fact that Milwaukee World Festival decided how they wanted to use the property differently? And how should a lessee basically ensure that that property be safe for any purpose? I mean, the inspections were done with the thought in mind that this would be a parking lot, the building would be torn down, the price presumably was negotiated with that in mind. So, you know, the lessee is a little bit removed from the transaction, which was an as-is, buyer beware, you're getting this property just like it is, to do whatever you want with it. And at the time, they were going to tear it down and build a parking lot. So we find ourselves analyzing whether a lessee of the property should be liable for the fact that they decided not to do what they bought the property for. How, if at all, does that impact our analysis?
Well, I think it was the great A&P case from, wasn't the Indiana one? I guess it was the Indiana one, the great A&P case that said, how can a vendee, or how can a lessee have greater responsibility than the owner? So, in my view, that is a correct analysis. The lessee should not have greater responsibility than the owner of the property. And another reason why Rule 51 doesn't make sense to me is, how does a lessee who vacates in 2009, they might know that GBJV is going to put this property up for sale, but they don't know who is going to buy it or what its purpose is going to be. They moved on and moved to their new place, and they're doing business elsewhere. Does a seller or a lessee have to keep track of a property over time to say, oh, by the way, we built this over here, or you might want to look at that? Or does that responsibility end, as it always has, at the end of your possession of the property? I say it should end because it's impossible for someone to keep track. In this particular case, after the lease was ended, the parties, JBJV and Charter, entered into a release which bound not only GBJV but also its successors, which would be MWF, and fully released Charter for everything related to that premises. So I think that contractual agreement is binding on MWF as the successor to JBJV, but I don't think we should require all lessees to have to enter into a release with the lessor in order to escape future liability when the lessor sells the property sometime down the road to someone that the lessee may not be aware of. That just extends liability too far in ways that can't be anticipated, and it's different than if I build a car or if I'm a contractor and I make a repair, I need to stand behind my work or my product. But and I have insurance for that. But that's a far different thing from a homeowner who puts in a pond at their property, or a company that thinks they're doing the safe thing by covering the pit when they remove the machinery, and then gets the A-OK from the lessor, who says, okay, we agree that you've turned in the property in an appropriate condition. They should be finished with that property and not have to face an uninsured claim coming back 10 or 2 or 20 years later.
Well, what are the facts that trigger that result for you? Because I think I could push you into saying that the tenant does not have any liability if the landlord knows or should know.
And that's definitely...
That's the rule of law?
The rule that we have.
All right, and you're willing to go along with that?
Correct. But if, for example, the tenant actively conceals something, then liability would continue.
Yeah, but by definition, then the landlord wouldn't know or have reason to know because it's been concealed. Okay. In this case, you have just a lot of other facts that help you out. The time, the duration, etc. But my sense is it wouldn't matter for what you want the rule of law to be, that 2 years passed or 6 months passed. Wouldn't matter to you. If the tenant left and the landlord had reason to know or knew, the tenant is not liable. And I use tenant, but it could be prior owner, lessee, etc.
And that's the way that the rule has worked, even in very short periods of time. So one of the cases that we cited was the Tyndall versus Pulte, I believe, Homes. It wasn't this Tyndall.
It was you.
Spelled differently. And that case cites an Illinois decision where the property changed hands, and on the same day, the new owner went in and was checking the pilot light, and there was an explosion. And the court said, in that particular case, that the new purchaser had inspected twice by themselves. They could have hired a professional to inspect. They chose not to. And so the responsibility for this loss was on them as the new purchaser who had the opportunity to inspect and had the reason to understand that there could be an issue with the pilot light and did not take steps to have it professionally inspected.
Counsel, the rule you want us to put forth could leave an injured person, as you represent in this lawsuit, with no recovery. If Charter were the only person with any money and MFW was a zero, some company that was not collectible, and Garland, the person who was the lessor of Charter, took a powder, the corporation was just a shell, they vacated, but Charter's got a ton of money. If we buy your rule, your client could be left with no recovery. Now, in this case, you're not there because you've gotten recovery from 2 of the other people you initially sued. But your rule will go beyond this case.
No, they were dismissed.
A parentage release comes about when there's a payment to the injured person by a defendant. Are you saying that that isn't what happened?
That is not what happened.
What did happen?
After the circuit court granted summary judgment, the circuit court's decision was very well written and very persuasive, and so we gave Charter and JV, I believe, a parentage release in exchange that they don't take costs against our client. But we would waive the right of appeal if they would not take costs. So there was no payment to them other than they would not be liable for a judgment for costs.
Okay, well, that's interesting. Thank you.
And in most circumstances, the loss would be uninsured because even if Charter had money and was a big corporation, there's a potential for recovery. But in most circumstances, if it was a homeowner or a small business, there might not be such a potential because there's no insurance.
So you don't think the result would generally be any different with your rule than without it? Okay. I was concerned about the injured person. Were we taking away all the pockets they could possibly collect out of?
I think a slim chance of that happening because of the lack of insurance, and it would increase the cost for everyone because they would probably a defendant would probably tender their defense to an insurance company who would feel compelled to appoint counsel and then seek a declaratory judgment that there's no coverage. So the courts and the counsel would all be involved in litigating an insurance coverage issue that need not be occasioned if we just keep the rule the same as it is.
Is there a difference we should take into account? Because the parties here, I know the analogy has been made by both counsel to home buyers, home sellers, and we normally think of just regular folks trying to buy a house. Here, I'm not quite sure that analogy fits. We're dealing with fairly big entities, fairly sophisticated parties. What, if any, relevance should that have to our determination?
None. And the Texas case I cited, when they talked about the weight of authority being to the contrary, they cited all commercial cases of that nature. It's all big corporations that changed hands. In the Occidental case, there was Occidental was the owner of a piece of property and it installed some machinery. When they transferred the property to the new owner, one of the new owner's employees was injured with this device that the Occidental had created, and the court rejected creation of the hazard as a basis for liability, continuing with the rule of Section 352. And all the cases they cited for the proposition that the weight of authority was to the contrary of the rule were commercial cases. I was surprised by that, but that was
all the commercial. All right, the commercial cases.
Yeah, they were all commercial property owners as opposed to private homeowners.
The homeowners, yeah. You went through a list of reasons why there might be actual or constructive knowledge, and I didn't hear you recount. My memory is that there were photographs as well.
Yes, in the reports.
What did the photographs depict?
The actual area with the big covers, because it was a big area and the covers were big things, and so they showed, and we did reprint some of them in our brief, and Ms. Schmidt put some in her appendix as well, and some might have been police photos, but there were expert reports with photos that came to MWF before the loss. It was some in January and some again in May.
Okay, thank you very much.
Thank you.
Counsel, paragraph 36 of the Court of Appeals sums up the case as follows. In sum, the undisputed material facts show that both MWF and Charter had reason to know that 1, there were large holes in the floor that led to a pit. 2, the holes were covered by plywood panels. 3, the panels were unmarked and untethered. Excuse me, and did not otherwise indicate that they hid the holes. To the extent that those facts should have notified Charter of a dangerous condition, they also should have notified MWF of the same. Unfortunately for MWF, Wisconsin law holds only the entity in possession and control liable, as the entity in possession and control is the only entity in a position to prevent the accident. What's the matter with that rule of law?
There's two things that are wrong with that paragraph.
Because that's a sum of the whole of
Correct.
a 17-page.
Correct. There are two things wrong with that paragraph. Taking it in reverse, I think that the court is in error in finding that MWF is the only entity in a position to correct the defect or the hazard, because the court at that particular time, Milwaukee World Festival may have been the only entity, but the court is closing its eyes to the fact that Charter created the defect in the first instance, and then Charter covered the defect, made it a latent defect, and then did not disclose it. It would have been so much better had that defect hazard risk been addressed up front for everybody
Did the
concerned.
lease require that? There are some leases that say, to the extent you modify the property, you've got to put it back
Right.
into the shape
And,
it was.
and this goes back to some of the questions I had earlier from Justices Gableman and Kelly about what was in the lease. When Charter left, it was to leave that building in a quote-unquote, or the pit, in fact, even the pit, in a safe and clean condition. So then that brings us back to, was this in fact a safe condition?
But there was no lawsuit on that, and no MWF or somebody looked at this and didn't ask for money or changes.
Milwaukee World Festival was not a party to that contract.
Whoever
Correct.
the owner was at that time.
Correct. And in fact, that would be substituting Garland Brothers, the owner's decision that this was safe,
Right.
for a jury's decision whether it was safe.
Well, the fact that Charter may have breached a lease with the lessor would mean that Charter owes something to that lessor. That doesn't necessarily mean Charter would owe something to a party that the lessor sells it to, as is known defects with the buyer conducting its own investigation of the property.
Correct, but again, I think that misses the point that it's Mr. Brenner that is the one seeking the compensation, and it's the allocation of the responsibility for the injury sustained by Mr. Brenner that's at issue here.
How
And
would a
Charter,
lessee ever protect themselves against what the owner of the property might decide to do in a subsequent sale? Because the proposition you're putting forward is, once you lease that property, you are on the hook, even if the owner of the property isn't.
I think that
That's a tough rule of law.
I think the rule of law isn't exactly that far. I think the rule of law is if you create a hazard, you're on the hook for the hazard you create.
You might owe a duty to the landlord to fix it, but, think of the lessee who goes out of business or leaves a property or a business that dissolves. The landlord would have the duty to fix the property, or the landlord could also sell it to someone as is. And the purchase price would be affected by what they sell it for, because they're selling the property, hey, it has these defects. Do you want it anyway? But
Well, and in this case, again, the defects were not disclosed, and that goes back to some of the factual issues that tie into 353.
except in a residential, I don't want to mix residential with commercial. In a residential transaction, there's a whole laundry list of what people have to do when selling a house to another. They have to fill out the forms. You can't lie about that. You have to do it right. The buyer needs to know what they're getting. Otherwise, you can go back to the seller. But in a commercial transaction like this, where you have sophisticated parties and you sell the property saying, hey, I'll sell it to you for this, and the buyer wants to just tear it down and build a parking lot, and so they may not conduct the kind of investigation or inspection that they might otherwise do, because they don't want to pay for an inspection of a building they never intend to use. I don't know what happened in that regard, but when you have sophisticated parties and you buy property as is, doesn't that make a difference?
I think a couple of things. Number one, we're making assumptions about the level of sophistication. Milwaukee World Festival is a nonprofit charitable organization that is engaged in music festivals rather than commercial real estate transactions. Second, the problem with that is, and I think it actually supports our position, and that is that the lessee doesn't know what's going to happen with that property, which is why it should have a legal obligation when it quits the property to make sure that it quits the property in a safe condition, because it has no control once it's into the stream of commerce as to what will happen. And I don't think it's too much to ask to hold them responsible for hazards they create.
Counsel, just 1 minute. You said there were 2 defects or 2 errors in the Court of Appeals summary paragraph. One was that Charter created it, it should be liable, or at least be on this.
And the other was some of the findings of fact up at the conclusion, and that goes to the fact that the trial court found that JBJV did not have reason to know, actually found that the environmental investigations would not have given JBJV necessarily information of the existence of the holes. and then it.
So you think the Court of Appeals found facts that the trial court didn't?
Correct, that there were competing inferences drawn.
Fine, thank you very much.
Thank you.
Well, thank you both for a very interesting argument and another look at restatement of torts, which goes on and on. We are going to take a lunch break now and meet, I think, with members of the bar and members of the community at a restaurant that is, quote, across the street, but our trusty sheriff and his staff are going to see that we get to the right restaurant across the street. We will be back this afternoon for our third argument, and I think they have it scheduled to start at 2 o'clock this afternoon. As you can see, we are chronically late. We should have been done at noon, so hopefully we'll be back near 2. Thank you very much, and we are adjourned.
Okay, which way do you lean? We thought about that when we sold our house in Nebraska. We have a pool, and we had a gate around it and stuff. But the first time we were going to take the gate out, so we had to make sure we were going to be liable for that. And they said we should have been fine. That's how I feel like
Once you sell it, as long as it was stated that it's like.
why should you be in charge of these things that they're going to do or not do? In the courtroom?
No, just a little way down there.
Somebody might ask you what you're doing.
Photography assignment.
Where's the 12:30. Thanks for coming, you guys. Was it worth it? Oh yeah. Well, it's really interesting when you're like saying, "Wait a second, if we vote on this, we're gonna change cases from here out," and that's what they'll always do. Is like, Brennan versus the Keith, whatever, and then it's like they said that they're liable. It's interesting how detailed it has to get when it comes up to this level. It's interesting how they create a new insurance market. More government. More government, more insurance.
I know, no, but I don't know any woman that.
More money in the economy. Do you guys need a note that it ended at 12:30, or you think you want me to call the office? How was your lunch, by the way? Well. Emma said, go to Coco's, get samples.
Well, yeah, of course, but you know, this is the way that law is this way already.
Old fake, old fake. Thanks.
They cut a hole in the floor.
But they're all, I mean, they really, they go in. That's why torts are yeah, but it came around. It's kind of interesting how the.
That's true, but he